We are on the record. Thank you, Bonnie.
You're welcome.
My name is Barb Hazelton. Do not be afraid. This is my first chair position on the zoning board, but I've been on this board for years. More importantly, these people know what they're talking about. So I think we're going to follow the agenda as posted. It is Wednesday, January 18th, 7:30 p.m. If you could please turn off your cell phones and refrain from talking, we would appreciate that. When you step up to the podium, please speak clearly into the microphone, state your name for the record clearly, and if you need to move, take the mic with you. You know the drill, Mr. Gleason. All right. We will begin with calendar number 10-2022. Cindy Hardy, the application of Jeffrey Merriman on behalf of Cindy Hardy regarding 26 Peach Hill Road. Before I turn it over to you, I just want to point out that Mr. Fullington and Mr. McGrath were not present at the last hearing, so they have reviewed the tape to come up to speed. Take it away.
Thank you. For the record, Wilder Gleason representing the defendant, Jeffrey Brown, who is with us tonight at the end of the first row. And this is the, I think, fifth or sixth lawsuit arising out of Jeffrey Brown's attempt to build a house on his property at 26 Peach Hill. Initially, he intended to live in that house, the existing house, while the new house was constructed. He has since moved his family off the site to a different place. And we're here because Mr. Hardy, his neighbor who initially approved the approvals to build a new house on the lot, changed his mind and has raised safety and other considerations, claiming that the Planning and Zoning Commissioners ignored those. So back, the history, you may all know, was that Jeffrey Brown got approvals in October 2020 to build about 11,000 square foot house with substantial parking and other areas on the property. And he then sought to get a variance to live in the existing house on that property while the new house was constructed. That variance was denied. And then he hired me to modify the zoning regulations to allow him to live in the house that existed while a new house was built. And we got an approval of that. And pursuant to that amended regulation, which now would allow for the first time homeowners in Darien of lots a minimum of half acre have the ability under the current regulations to seek approval to build a new house while they live in the existing house. It's a cost-saving, environmentally sensitive way of doing things, but it's got to be through the special permit process by which the Planning and Zoning Commission assures there's no adverse impacts on neighbors. We got that special permit approval. The Hardys took appeals of both the zoning amendment and the special permit approval. Subsequently, Jeff and I talked and we said, could we go back to the original October 2020 approval, which wasn't part of the special permit, live in the house while you're existing house while you're building a new one, part of it. And we talked to Planning and Zoning staff, and they said, yep, that's okay, come in with your new plans. So we came in with our new plans and got the zoning approval and the building permit. And pursuant to a statute, Section 8-7 of the Connecticut General Statutes, which allows a successful applicant who received approvals from the zoning enforcement official and the building official to publish notice of that decision in a local newspaper. And that's what we did. And the state statute says if you publish notice in a local newspaper of substantial circulation in the town, and the neighbor fails to file an appeal within a time period established by the Zoning Board of Appeals, which you have established or your predecessors established as 30 days, then the appeal rights of the neighbors or any other aggrieved person are terminated. And the statute is absolutely clear. And that's what we did. We published notice. and waited 30 days, and then started construction, and 32 days after the appeal period had run, Cindy Hardy filed this appeal. It's untimely. And so I want to go through why. And here's the appeal infirmities. And you each have a copy of this presentation in front of you. I gave you all of the slides that I'm going to go through, so if you can't see it here, you can see it right in front of you. And Woody has a copy as well. Bonnie, if you want a copy, I can give you one, but I don't think you typically want one.
I'm fine, thank you.
Okay. And I have given a copy to Mr. Merman, the applicant's, Cindy Hardy's attorney, who's here. So the first claim is that the appeal is not timely. It was not filed within 30 days after we published notice, which set a deadline of July 11th. On July 11th, the appeal rights of any neighbor who was aggrieved terminated. And that's pursuant to Connecticut General Statute 8.7 and 8.3F, and I'll review those in this presentation.
Mr. Leeson, real quickly, where did you publish notice?
In the Stamford Advocate.
Is that the only place?
Yes.
And they have reciprocal publications in other papers, do they not, or no?
They do.
Okay.
But and I have a certification, which is part of the record, but it's also one of my slides, where there's an affidavit from someone from Stamford Advocate certifying that on June 10th, 2022, the notice was published. And I have a blow-up in one of the slides is the actual notice that was published, the text, and I'll review that for you. So the second ground for the appeal being denied is that the applicant appealed the building official's decision to issue a building permit. And appeals of a decision to issue a permit by the building official under the town charter go to the Building Board of Appeals, because the building official doesn't enforce zoning regulations in Darien. The zoning enforcement official enforces zoning regulations in Darien. And that's what the town charter says. So if Cindy Hardy wanted to appeal the zoning permit issued by the zoning enforcement official, she could have appealed it to this board. But what she's appealed is the building official's building permit, claiming that he didn't have authority to issue the building permit because it doesn't comply with the zoning regulations, which he has no authority to enforce. And those are the three infirmities I have. I understand you probably are going to just address jurisdiction. Is the appeal timely? Was it filed appropriately, et cetera? And you don't want to get into the merits, because Cindy Hardy makes all sorts of claims about how this is a drastic change from what was originally approved in October 2020. And I have Neil Hauk, a very experienced architect with over 30 years practicing in Darien, who's the architect for this project, and Doug DeVesta, our civil engineer with a similar experience processing applications in Darien, who would testify that the changes that were made reduced the original 11,500 square foot house down to 7,500 and made other changes which essentially reduced impact. And when applications that have been approved are later shrunk, commission staff has authority to approve them without going back to the boards. It's reducing impact, reducing effect on neighbors, construction time, all that sort of stuff. And that's the nature of the changes that were made. It's a smaller house. It's 7,500. It has less impervious surface, et cetera, et cetera. There's a lot of changes, but all of them reduce impact, which falls within the ambit of the authority of the zoning officials, the zoning enforcement official and the building official, to approve without going back to the respective boards that were initially approved this. So the Darien Code of Ordinances in Chapter 629 establishes a building official I've highlighted the operative language, which is the building official shall enforce the general statutes in their application to structures within the town and the provisions of the building code. Building official, building code. The next slide is subsection B of section 29 of the Code of Ordinances, that's chapter 8. The zoning official, who's referred to as the zoning enforcement officer, shall be responsible for the enforcement of the zoning regulations of the town of Darien. Zoning official, zoning regulations. We don't have building official zoning regulations. So, section 8-7 of the Connecticut General Statutes establishes your jurisdiction. And it says that the concurring vote of 4 members of the Zoning Board of Appeals, that's a supermajority, we can lose 1 vote out of 5, is necessary to reverse any decision of the official charged with enforcement of the zoning regulations. 4 of you have to approve a reversal, finding in favor of Cindy Hardy's appeal here. An appeal may be taken to the Zoning Board of Appeals by any person aggrieved, and this is the important stuff, and shall be taken within such time as prescribed by a rule adopted by the Zoning Board of Appeals. I'm going to skip 2 slides. This is your general rule, section 1126. And in this, you and your predecessors have established appeals to the ZBA from a decision made by an administrative official shall, that's mandatory, shall be made within 30 days from publication of the decision or determination. Got 30 days. That's in the regulation. And going back to the statute, it says if it's established by the board, that 30-day period applies. Now, you could have said 15 days, and that would have been enforceable, but you gave them 30. And then the next part of this says that the aggrieved person has to file with the zoning commission or the officer from whom the appeal has been taken and the board a notice of appeal specifying the grounds. The applicant did that with respect to the board. The appeal period shall commence for an aggrieved person at the earliest of 3 different triggering dates or circumstances. Receipt of the order. Now, receipt of the order or decision usually comes to the applicant, and if the applicant is upset with it, he would take an appeal. So this is number 1, addresses the applicant, okay, typically, because the order isn't usually given to the neighbors. 2 is upon publication of a notice in accordance with subsection F of section 8.3, and I'll turn to that momentarily. And then item 3 is upon actual or constructive notice of such order. So the publication, item 2, is addressing notice to the neighbors. You're supposed to notify them. How do you do it? You publish in a newspaper of local circulation. We did that in the Stanford Advocate. Once that was done, the clock started to run. The other trigger is upon actual or constructive notice of such order or decision. That would mean Cindy Hardy looks out her window and sees construction's going on, and there's a lot of activity. And she then says, wait a sec, what's going on? That's constructive notice, and she would have an obligation to then find out what's going on, what happened in 30 days under your regulation to bring in an appeal. What's operative here is we published notice 60 days plus prior to her filing an appeal. So section 8.7 references publication of notice in accordance with subsection F of section 8.3 of the general statutes. So now we have subsection 8.3F. And this says no building permit shall be issued for a building without certification in writing by the official charged with enforcement of such regulations. This is the zoning regulations. So you can't start construction without a zoning permit from the zoning enforcement official. that certifies that the construction conforms to the zoning regulations. And the statute was amended in 2003, as the town council's wonderful brief points out, to specifically incorporate publication notice. Because there was a case where somebody had spent hundreds of thousands of dollars building a house, and the neighbor didn't receive notice because they lived in Florida for 6 months of the year, came back and sought to bring an appeal. And if you're investing in a brand-new house in Darien, you're spending serious dollars. And you want to be sure you can do that without having neighbors taking appeals. And so the state legislature, at the recommendation of the Connecticut Bar Association Planning and Zoning Commission, amended the statute to give an applicant who succeeds in getting a zoning permit the right to publish notice of that receipt and terminate neighbors' rights to appeal. That's what happened here. So that certification, we have to the statute says the zoning enforcement official has to inform an applicant who succeeds that he has that right to publish notice. And that the town's CEO has studiously done, okay? So we published notice in a newspaper having substantial circulation in Darien, and it stated that the certification had been issued. Now, the statute, this section 8.3F, the last sentence, which I didn't highlight because it would just be all yellow, establishes the requirements that have to go into the notice. The notice has to contain a description of the building, use, or structure, the location of the building, use, or structure. It has to identify who the applicant is, the successful permit holder. And it has to have a statement that an aggrieved person may appeal to the Zoning Board of Appeals in accordance with the provisions of section 8.7. So you have to describe what the building is, the location of the building, who the applicant is, and tell the world that you can bring an appeal. This is the notice we published. And it says, to all persons of interest, please be advised, on June 8th, the Darien building official signed a building permit application of Jeffrey Brown for construction of a replacement residence at the property located at 26 Beach Hill Road, Darien, Connecticut. Please also be advised that before June 8th, 2022, the Darien Zoning Enforcement Officer signed a zoning permit application of the Jeffrey Brown for construction of a replacement residence at the property located at 26 Beach Hill Road, Darien. We identify the property, we identify the applicant, we identify what's involved, the building, it's a replacement residence. We then say, within 30 days of this notice, any aggrieved person may appeal to the decision of the ZEO to the Darien Zoning Board of Appeals in accordance with the provisions of section 8-7 of the Connecticut General Statutes. So we did all four things that the statute requires us. And it says, and/or appeal the decision of the Darien building official to the Building Board of Appeals. So our notice said, if you want to appeal the building official, go to the Building Board of Appeals. This is the certification from the Stamford Advocate. It's an affidavit that we received from someone of the Stamford Advocate. There's a notary here. It says the publication date is 6/10/22. That's our slide. I forget what slide that is, but it's in the record because it was attached to my brief, which was submitted. So June 10th, the 30-day period started. July 10th, it ended. On July 11th, the appeal rights no longer existed. They were terminated, per the statute.
And when did she file the appeal exactly?
August 7th.
August 7th, okay.
And the appeal of the ZBA is not timely, to the ZBA is not timely filed. The time to appeal expired at 12:01, July 11. The appeal was filed August 11, sorry. 31, actually it's 32 days late, I miscounted. It's 32 days late. per chapter, and then I'm repeating things that I've already told you, that 29B of the Darien ordinance, the Darien ZEO, not the building official, is charged with enforcement of zoning regulations. And the Hardy appeal of the, now what this appeal is, it's an appeal of the building permit issued by the building official. And that should go to the Building Board of Appeals, which the applicant has not done. You don't have jurisdiction to hear appeals of permits issued by the building official.
So we'll talk about that. You know, my understanding is we've got an order here to follow. We have to decide if this appeal was filed in a timely manner. And if it was, then we go to the next part.
Okay. I'm happy to stand down at this point
I have
because,
2 questions.
Go ahead,
Sure.
please.
So question 1 is, what is your basis for your statement that the Stamford Advocate has substantial circulation in our town?
the town of Darien publishes notice in the Stamford Advocate on occasion. It most regularly uses the Darien Times, but the town of Darien itself publishes notice in the Stamford Advocate, and Jeremy Ginsburg can confirm that for you.
Okay,
So if
you
the
don't-
town's doing it, then I assume it has substantial circulation. I don't have any evidence to that, but I do know that the town uses the Stamford Advocate when it's not convenient to use the local weekly paper.
Okay, and second question is it your view that there's nothing that the building official could do that is appealable to this board?
Correct.
Okay. I don't agree, but
Well,
Just a couple questions. Number one, do you have a date of when construction actually began, where a reasonable neighbor would be able to say, oh, there's something going on in that property?
well, we waited until the 30 days had lapsed, so I believe it was sometime in July.
Okay, so at that point, there was construction activity going on the property?
Right.
Okay. Were there notices put into neighbors' mailboxes about that there was work going to be happening on the property? And that's a pretty standard thing to do, if I'm not.
That was not done,
Why not? Do you know?
because it's not required.
Okay. Has Mrs. Hardy?
And
indicated-
given
Yeah.
the history of the litigation here, and the fact that the appellant here had changed her mind, it seemed a wise decision.
She had already confirmed that she didn't have any problems with the construction before?
Absolutely, she had confirmed it for the initial approvals, and then when we sought to live in the house and go through permits to live in the house, there was, I mean, we've had 5, 6 lawsuits
Okay.
and appeals,
Has Mrs. Hardy indicated?
counting this one as well.
Has she indicated what changes she would want to make to the?
We've
Full
had
building?
extensive settlement negotiations about this, which I cannot disclose to you, but suffice it to say that we found their demands to be totally unreasonable, requiring conditions that would require our client to spend lots of money with no help.
Okay.
There was no meeting of the minds. There wasn't even a gesture to trying to resolve this.
Okay. That's it for me.
Jenna, anything?
No, that covered
Any
everything.
questions, John? For Wilder?
Any specific reason why notice wasn't made in the Darien Times, or?
We wanted to publish as quickly as possible. We got the decision on June 8th. We published June 10th. We wanted to start construction. We'd been delayed many, many months because of the litigation. Not just this, but tons of other lawsuits.
Woody?
No, thank you. We do have
A number of people?
multiple town staff here, including town council,
Okay,
if they would be helpful, if board's comfortable with what's been presented. Certainly want to hear from Mr. Merman, I
Yep.
think.
okay. Thank you, Mr. Gleason. Mr. Merman?
Wilder, Wilder. Yeah, like a copy of it.
whenever you're ready.
Thank you. Jeffrey Merman on behalf of Cindy Hardy. If you would like, I'll address just the timing, or I can address the timing and the jurisdiction and all the other infirmities at the same time.
If you can focus on the timing, I think that's a primary issue,
Sure.
and then we can touch on, we want you to feel heard and
Thank
your
you.
arguments made.
Could you
Okay.
spell your last name for me, please?
M as in Mary, IRMAN.
Thank you so much.
Thank you. So just to answer some of the questions that were asked of Mr. Hardy, one wonders why, when this new building permit was sought, no notice was given to Mrs. Hardy, the abutting neighbor who had already voiced issues and concerns about the project. To answer your question with respect to have we had discussions, yes. And what Mrs. Hardy is really concerned about is the safety of construction. So you'll recall from the materials that have been provided that the properties share a common driveway, which is only 12 feet wide. Pedestrians use that driveway, primarily school children going to and from the bus stop at the end of the driveway. And the Hardy's concern from day one has been to make sure that construction vehicles and other vehicles using the driveway are using it safely, so that not only can cars and trucks pass safely, but that children aren't going to be hit by these vehicles. And that's been the primary focus of their concerns from day one, and we believe that Mr. Brown has never been willing to address seriously those concerns. And that's what we've been trying to accomplish from day one, not to prevent him from building a new house, but to make sure not only that the house is built in compliance with all the regulations, but that it's done in a manner which secures the safety of the Hardys and everyone else using that property. There are other neighbors who come down from above to use that driveway to get to the school buses as well. So that's the primary concern, and that's what has triggered much of the litigation, fear of being killed, frankly, in your own driveway. So with respect to the issue of timing, we cannot divorce the question of facts from the law. So here's what we know with respect to the timing. The Hardys never had noticed that a building permit had been sought. It was published eventually in the Stamford Advocate, not in the local newspaper. And with respect to the timing, the law is clear that although Mr. Brown relies on a 2003 legislative amendment to support the conclusion that the time period runs no later than publication, and thus Mrs. Hardy did not appeal within 30 days of publication, while we agree that that did not happen, that is not where the legal inquiry must end. Where there is no direct notice to a person affected by a decision granting a permit, the question becomes whether Mrs. Hardy had actual or constructive notice of the issuance of the permit. She had neither. Mrs. Hardy did not have actual notice until she learned from her attorney that a permit had been issued. Her attorney learned that the permit had been issued from Attorney Gleason more than 30 days after publication. Mrs. Hardy filed the appeal within the 30-day period following actual notice of the issuance of the permit. So the question then becomes, did she have constructive notice? Here we need to turn to the law. In Hall versus Burns, a 1990 Connecticut Supreme Court case, the court stated, quote, constructive notice is premised on the policy determination that under certain circumstances, a person should be treated as if he had actual knowledge, so that one should not be permitted to deny knowledge when he is acting so as to keep himself ignorant. And that's the key language, so as to keep himself ignorant. Did Mrs. Hardy do anything here to keep herself ignorant of the granting of the permit? No. She had no reason to be checking the Stamford Advocate or any other newspaper every day for something about a building permit when there had been no idea given to her that a building permit had been sought. There was no activity at the Brown residence for 2 years. There was no construction. There was nothing happening on the Brown residence to suggest to her that a building permit or any other permit had been issued that would permit construction. Did Mr. Brown, through his counsel, take steps to keep Mrs. Hardy ignorant until Mr. Brown strategically allowed the time to appeal had passed? The answer is yes. As you've heard, there was no notice of the issuance of the building permit given to Mrs. Hardy. There was no notice that a building permit had been sought. Therefore, in the absence of constructive or actual notice, Mrs. Hardy will be deprived of the due process of law to which she is entitled in connection with the construction of a home on a abutting property, especially where, and we can get into the issues of problems with the building permit itself, especially in light of the fact that it didn't address the wetlands issues that are new, because this permit is different from the permit that was originally sought. So that is the reason why her appeal was timely filed. In reality, she neither had actual nor constructive notice. She didn't do anything that kept herself ignorant. It was Mr. Brown that kept her ignorant, and no doubt intentionally, so as to make sure, in his view, that her appeal was not timely.
Mr. Merman, when did she file the appeal exactly?
I believe it was either August 10th or 11th.
Okay.
So it was, she got actual notice at the end of July or the beginning of August, so it was well within the 30-day period of actual notice.
Okay. I know there are a lot of other things to discuss on
Would you
this.
like me to address the jurisdictional issue next?
What do you
Or
think?
do you want to vote?
Should we do that, or should we table it and hear from town council about the timing issue? Kevin?
I just ask one question if we're
Yeah,
going to move on.
please.
And I agree with the premise of what you're saying, but isn't your argument basically fairness, that the state statute adopted in 2003 is unfair, that you can't expect a homeowner to be scouring newspapers every day to look for notice? Isn't that fundamentally your argument?
And that's a due
That it's
process argument, yes.
Yeah, but isn't that one that's properly addressed to the state legislature, not here, that your statute is unfair, that it's depriving people of real notice? Isn't that fundamentally what you're saying?
Well, what I'm saying eventually is, let's assume for the sake of argument that you rule against me. Obviously, I'm going to take an appeal. So on appeal, one of the issues will be whether that amendment to the statute is constitutional insofar as does it deprive
Right.
Mrs. Hardy and others of due process. Do we want to go down that route now? So that issue has not been addressed by the Connecticut Appellate Courts.
Right, but you're asking us to do what a court hasn't done, which is make our own supposition that what the state adopted as a statute is unconstitutional, right?
And I think you have the right to do that under the facts of this case where she actually never had notice. One other thing before I forget, and this goes to the issue of the notice itself, and this sort of goes somewhat into the jurisdictional question, but it does affect the timeliness question. So, as Attorney Gleason suggested, the question is whether the notice that was published was adequate so as to start the clock running, if you will. And if you look at the notice that was published, it talks about the decision of the Darien building official needing to be appealed to the Building Board of Appeals. Now, we believe that the proper appeal from the issuance of the building permit is to this agency. So if we are right about that, then the notice is defective, and therefore the clock never began to run with respect to the publishing of the notice. So, and I'm happy to discuss why this is the appropriate place to take the appeal when we're ready for that.
Okay. We don't have a building board of appeals.
Then where was I to go?
Interesting. We're going to hear from some town officials. Do you have questions for Mr. Merman? Anybody?
I have one, if you don't mind. Mr. Merman, when was the case that you cited, Hall versus Burns? Say 1990?
I believe it's a 1990 case, let me just make sure. A 1990 case, and I have the site if you'd like it. 213 Connecticut, 446 at 479.
Thank you, Mr. Merman. So
So
I'm
you
going
could
to ask,
you can allow Mr. Gleason to rebut some things if you
Okay.
wish, or go directly to town council.
Mr. Gleason, you want to comment before we go to town council?
I'll just take one moment, which
Thank
is,
you.
the Burns case preceded the statutory amendment. It's a 1990 case. The amendment was done specifically to give vested rights to applicants who succeed and publish. It was exactly designed to allow people to do what Mr. Brown did. There's no, the statute doesn't require us to be fair or nice or notify neighbors. It doesn't require that. It only allows us to discharge the neighbors' rights to appeal by publishing in a newspaper of local circulation. So,
Before you leave, can you comment on the Building Board of Appeals, why that was written into the notice as opposed to
because the
zoning?
building official decisions regarding building permits and enforcement of the building regulations by the town charter go to the Building Board of Appeals. There is no statutory framework that I know of where there are some towns where a building official acts as the zoning enforcement official because they don't have enough activity. And years ago, when I first started practicing, our building official was the ZEO. So you could have a building official have a decision of the building official appealed to the ZBA when it involved his duty as enforcing zoning regs.
Okay. I'd love to hear from our town council, Mr. Wayne Fox. Is he here?
Or Patty.
And Patty, I'm sorry.
Good evening, Mr. Fox is here, but I'm with him. I'm Attorney Patricia Gao from Curtis Brinkerhoff and Barrett. I've worked on this matter also.
Could you spell your last name, please?
Gaug, G-A-U-G.
Thank you.
One thing I would like to address, an issue that was raised, was Mr. Attorney Merman's statement that there has to be actual or constructive notice rather than publication, in addition to publication. The case law is replete with references to the fact that publication is considered constructive notice. So I think that answers that question. The whole purpose of publishing is to provide people with constructive notice. That is, they're charged with notice. And I think that that amendment that was made after the Monroe decision was made to clarify that point. But in cases going back many years, the courts have acknowledged that publication is considered constructive notice. Are there any other questions that anyone has?
One question I have is, what is your view on if the Stamford Advocate qualifies as a publication that has substantial circulation in our town?
Yes, we would consider that general substantial circulation in this town. We have published notice in that Stamford Advocate regarding town actions.
Questions?
Maybe I can.
Yes.
At our, what was it, October 19, I think, quite a while ago when we started. Mr. Merman brought up a couple of cases, Monroe, I believe, and Wiltzius, to, I guess, argue about the circumstances of the timeliness. Did you find that those cases were applicable to
Well,
this proceeding?
Monroe is no longer applicable because the amendment was made after that decision was rendered, and it was made directly in response to that decision to clarify that publication is considered constructive notice. Wiltzius, I don't find that applicable because the timeliness issue there had been decided in a previous proceeding between those parties, and in the case that Mr. Merman cites, the court declined to address the timeliness notice because it had been decided in a previous case.
Okay. Is there anything else I should be asking here? So in your mind, should we be addressing these things in order? Should we be considering all arguments at once?
I would suggest it's how you wish to proceed at this point, but the jurisdictional issue is also a legal issue that's before the board. So you
Okay.
could reach that decision if you so choose.
Okay,
Can I just make one more comment, please?
please.
And that's to address the question regarding the Wiltshire case. I just will observe that that is a 2008 case after the amendment, and the question turned on that when it was that there was, the appeal was filed within 30 days of actual notice. So,
But you don't dispute that there are other cases that say publication is equal to constructive notice?
I'm not aware of cases that use that exact language, but it's certainly an interpretation which many have made. But I don't think it should be applied in this case for the obvious reasons that we've already talked about.
Can I ask one more question? At what point did Mrs. Hardy and you commence discussions with the applicant on the construction prior to the issuing of the building permit? Like, how long were you guys talking before this even was an issue?
I'm not really sure because it predates my involvement, but
When does your involvement start?
my involvement started in September of this year, September of 2022. But I'm guessing, and Attorney Gleason will obviously have a better fix on when discussions began, but I'm guessing sometime as early as 2020?
No, we had extensive settlement discussions in the trial of a case that just was argued this morning before a judge in Superior Court. And Judge Provatador spent, I think we had 3 different sessions over a month where we went back and forth to see if there was any possibility of a settlement. The judge worked extraordinarily hard, and counsel did too, but there was just no way to bridge the gap. And frankly, it was just not possible.
I can say that the last set of discussions I was involved with, and those occurred, I believe, in October of 2022.
And this was before we had briefed the case that we just argued, so that would have been, or maybe it was after it was briefed. It was this fall
It
that
was
we
this
had
fall.
those discussions.
But when did it start? You said 2020 was when this?
Well, we brought the application to amend the regulations to allow the Brown family to live on the property while building a new house in 2021. And then there were appeals flowing from that decision.
And there are at least 2 court cases pending?
There's 2 court cases pending. An injunction action to enjoin the construction because of impact on the driveway. And when the injunction hearing was held, Mr. Merman's client declined to proceed, but that process
It wasn't held. It did not go forward.
did not go forward,
So,
whatever. And,
but it's a claim that the use of the driveway, which is an easement, has been overburdened.
By the construction.
By the construction, yeah.
and-
Have there been safety accommodations made over the course of the 2 years?
I believe we would disagree on the answer to that question.
Okay.
We would say no, he would say yes.
Absolutely.
Okay.
And I would note for the record that in approving the special permit that the planning and zoning granted to live in the house while we're building a new one, they imposed minimal safety considerations after hearing the very complaints that Cindy Hardy is raising now.
Well, she's not raising them now for the first time.
Well, she's raising the same complaints that we heard in the special permit application and the amendment application, which were a consolidated appeal. And the planning and zoning listened to those and made a decision that they were not going to impose serious safety considerations. Jeffrey Brown has gone beyond that in terms of what he's done to improve the conditions.
In your opinion, yes.
Well,
Okay,
it's clearly it doesn't satisfy Mrs. Harding.
sure, that's why we're all here. So, okay, is there any, Mr. Berman, anything else?
No, thank you.
Thank you. Is there anybody else that would like to be heard on this case?
Barb?
Yes, please.
If you don't mind,
Please.
I probably should have asked Ms. Gog when she was up here, but if you don't mind, I think it'd be
Yes.
good to get on the record.
Okay.
The jurisdiction question.
Ah.
Do,
Ms. Goggin, do you mind coming back up, please, so we can talk to you about the jurisdiction? So there are a couple issues for us to consider. The timeliness of the appeal when it was filed, and in giving that weight, whether it's constructive or actual notice, which is relevant. But the other issue is jurisdiction. Does this fall before the zoning board, in your opinion, or is this an issue for planning and zoning?
This is actually an appeal that should have been brought to the Building Board of Appeals. And I think there was a question as to whether or not there is one. My understanding is there is one. It has been constituted. So there isn't one in existence. And that's where this appeal should have been taken, based on the research I provided to you in the memo. It should not have been brought to this board. And I think that you can reach that jurisdictional issue depending on how you decide it. If you find there is no jurisdiction, then there's really no basis to proceed beyond that.
Is your, same question that I asked Mr. Gleason, is it your view that there is nothing the building official can do that is appealable to this board?
Not that I'm aware of in connection with this case, no.
Well, I'm just saying, put aside this case, because I just want to be careful about what's on the record, about whether town council believes there's anything that the building official can do that's appealable to this board.
I don't believe there is. I think the references in some of the cases to being able to appeal from building permits to the zoning board of appeals, in certain towns, as Attorney Gleason mentioned previously was the case here, the building official acts also as a zoning enforcement official. So I think that the citations in those cases, such as the Reardon case that Attorney Merman has cited, they're not applicable unless, because that town may have a different setup with how they deal with their buildings.
So does the building official never make a determination related to zoning?
No, the way it works is the property owner has to go, once everything's done, they have to go get a zoning permit first from the zoning enforcement officer. And then they have to go to the building official with that to get the building permit. So that's how the enforcement of the zoning regulations takes place, is through the issuance of that zoning permit, which is a prerequisite for the building permit.
So this in short, the answer is no, the building official never makes ever a determination related to zoning.
Only to satisfy himself that the zoning permit has been issued because, and therefore it meets the zoning regulations. Any other questions?
Woody,
I think that's good.
you think it is? Okay, anybody? Last chance? All right, so what we're gonna do is, we're gonna close this hearing, and we will deliberate later on this and discuss how we move forward, yes? Yes?
I'm sorry.
Could you come up to
Mr. Merle, please come to the
podium,
microphone.
please? Thank you.
But are you closing the hearing to vote solely on the timeliness issue? Because I haven't addressed comments to the jurisdiction.
Why don't we do that? Why don't you quickly address the jurisdiction issue in
Sure.
case we move past the timely issue tonight?
Okay.
Okay.
So, so some of my thunder was I won't say thunder was taken, but, so in Reardon versus Zoning Board of Appeals, which is a 2014 Connecticut Supreme Court case, the Connecticut Supreme Court made it clear that the granting or denying of a building permit is an obvious example of an appealable decision to a ZBA. That's what they said, and that's what we did. So town council and Mr. Gleason, have looked at the town charter and the zoning regulations and worked their way around suggesting that the ZBA does not have jurisdiction, but it's important to remember this. Local zoning charters and laws cannot contravene what the Supreme Court has said in interpreting state law. And for that proposition, I say, when there is a conflict between local zoning regulations governing the powers and duties of the ZBA and the law, the regulations must give way, as the Connecticut Supreme Court made clear in Farnsworth versus Town of Windsor, a 1963 case that is still the law. And for Mr. Woodside, the citation to that is 150 Connecticut 484 at 487. So, Connecticut Supreme Court has made clear that an appeal from the issuance of a building permit by a building official comes to this agency. Darien zoning regulations, town charter can't contradict the law of this land. Thank you.
And doesn't, beyond the case law, doesn't this statute itself say something, forgive me, I'll paraphrase, something to the effect of any determination by any town official related to this chapter, which is the chapter about zoning, may be appealed to the Zoning Board of Appeals?
I believe so. I don't have that citation from me, but I think it was part of the papers that we provided earlier.
Okay, thank you.
Thank you.
Thank you. Ms. Goggin?
Sorry to take up your time. I just wanted to clarify one point. That Reardon case that is relied on as by Attorney Merman, that involved the town of Darien, and I worked on that case. And that statement was actually dicta. That was not even an issue in that case. That case, the question was, when did they have constructive notice, the property owners that appealed? So it wasn't an issue of the building permit being appealed. So any language in that about building officials and who to apply to was quotes from other cases that didn't pertain to the facts of that case.
But what about the state statute that says any determination relating to zoning can be appealed to the Zoning Board of Appeals and the supremacy of state law over a local zoning code?
Well, I think what the statute actually says is that any decisions affecting zoning made by the officer charged with enforcing zoning regulations. And in that case, in the town of Darien, that is the zoning enforcement officer.
Is it different in other towns?
Some towns, the building official also enforces.
Can wait, okay.
Yes, but there's a charter provision here that divides those responsibilities.
Okay. A lot of heavy legal language. Thank God Kevin's sitting to my right. We are lay people. I think you all did a nice job laying it out. Thank you for keeping it simple. Anybody else wish to be heard on this case? Okay, I'm going to close this hearing and we will deliberate later. We will talk about the timing and the jurisdiction. To be continued. Thank you. Okay, we're doing great. That was only 55 minutes. I'm going to keep it clicking. All right. Second issue, calendar number 14-2022. This is the application of Beatrice DeSantis and BM Design on behalf of Elvis Robles with Crypto Life LLC. And I will just, to allow the construction of a one-story and second-story attic and an attic story addition. And I will just add for the record that myself and John McGrath were not at the first hearing, so we have reviewed the tapes. Mr. Robles?
My name is Elvis Robles. Mrs. Beatriz, she was the one in charge of this, but she couldn't make it today.
Okay.
She's sick. I wasn't prepared to say much, but
This better be good.
but
Okay.
well, last time I was here, we were gonna get a copy of the title insurance plus the regular insurance. But I got a copy from an attorney, but it doesn't specify anything except the property address. It doesn't say two-family, one-family, or multifamily.
Okay.
So that's basically, doesn't change much. Same with the insurance, regular insurance. It only address the property address, and that's
Okay.
it. But I spoke to the previous owner, which is the son of the trust of the owner that built the house, and actually bought the house in the 50s. So I explained to him what happened because he sold it to me as a two-family, and it was at 2 meters, being taxed as a two-family also. So he sent me a letter just now while I was here, because he was supposed to be sending it to me before, last week, but he was too busy, whatever. I have an email that I could show it to you, you guys can read it, but specifically he says that the property, since he's 64 years old, since he's alive, the property has been two family, and there was always 2 meters. And he helped his dad manage the property as a 2 family. This is why he sold it to me as a 2 family.
So the only indication, I'm sorry, you gonna say something, Woody?
Well, we just need some facts.
Yeah.
If you have some paper or some
I wouldn't
actual
have any.
document, something that you can submit.
The only fact is that I bought it as a 2 family. So I pay taxes as a 2 family. The owner, the previous owner that sold it to me, it's here stating since he's born, 1964, it's 2 family. So what else, I
Didn't
mean,
the previous owner pass away?
yeah, but the trust, the son just
This is the
wrote it.
son.
The son that sold the house to me. It wasn't the only property I bought from him. I bought 2 properties. One as a 1 family and one as a 2 family. When I spoke to him over the phone, he said to me, look, I wouldn't dare to cheat on you because I'm already selling you a 1 property as a 1 family and the other one as a 2 family. So I don't know why the town is doing that. As a matter of fact, he said to me, which it's not in the letter, but he said to me, 2004, like it's in the records, the town inspectors went into the house, saw the 2 kitchens. They did not say anything because according to him, they were friends with his dad. Actually, one of the town inspectors or officials, he said that wrote or actually draft the plans, presented and approved by them. So he said, I don't know what happened, but all I know is 2 family. The inspectors were here, and he helped them actually drafting the plans. So if that was illegal, he should have said something to my dad. He should have said, hey, look, what the heck? Why you
He
have?
should have, but he
Yeah.
may not have known. Well,
Well-
the proof is, I mean, other than the 2 meters, is there anything documented that says it's a 2-family or a multifamily?
They have a copy of the zoning stamped drawing.
Certificate of occupancy?
Right, no, drawing that shows 2-family dwelling. Zoning officials signed it, stamped it. If they was wrong, they should have said wrong, except say wrong.
And when was that?
They have a copy, everybody has a
When was
copy.
that? That's-
2004?
Are
2004?
we talking about the survey?
Yeah, the survey.
The survey. It's just a survey.
Okay.
So the survey was actually seen by them, whoever was back then. I'm thinking the same people that saw the survey, the same people that went to the house, the same people that were friends, according to Jack,
Yeah.
not me, they were friends. So why am I supposed to pay somebody else?
I understand. You were
If-
given a certain set of information, you buy a house with a certain set of expectations, and now it turns out to be not what we thought.
Well, I don't know if, I mean.
Tell me
well,
this, what's going on with the house now? What have you done to it?
Right now it's empty. I mean, when I bought it, I immediately, the house was a mess. There was 2 families living. I gave them 2 months to live. They left, but it was a mess. There was rats. The kitchen was falling apart. Everything was bad completely. So I couldn't just leave it like that, smelling or getting worse. So I gathered everything.
Okay?
And they was even the permit, and that's it.
Okay.
So why I gathered it? Because it was a fire hazard. Gathered it, it's my point of view. I'm a builder myself, so
Yes.
it's better. While I wait.
So what triggered this? Did you pull permits to do the work you've done? Have you
No,
done-
I started pulling permits with the drawing, with Beatrice did, to actually do the work, to actually make it a little bit bigger and know everything.
Got it.
That's the only thing. So I didn't do anything as far as adding, changing, just demolition.
Okay.
Are you remodeling this as a 2 unit? Or
That's the idea. I said that's why I bought it, because I have 5 kids altogether. My purpose was, I have other investments, 5 other properties. 1 kid, 1 house. 1 kid, 1 house. This is why I bought it. Otherwise, I wouldn't have bought it. I mean, this is it. I have my realtor actually with me that since the beginnings, he talked to the other side, talked to everybody, and this is why he wouldn't tell me something that somebody else was cheating or whatever. So, I mean, I would like him to come over here. And
Wait, just
explain.
before you get that, so just two questions. One is, so did you get a permit for the demolition that's been done?
No.
No? Woody, is a permit required for?
Yeah, yeah. And there was some reframing, there was some new
The
wiring.
framing was there because 2004, remember, 2004 was added. The house had 2 additions on the back and a little bit on the front. So the wood, obviously, any kind of wood unless it's before 50 years ago remains new because it's already covered with sheetrock. You actually they went to my property 3 weeks ago without permit. They entered the property. The door is not locked or whatever because my realtor is showing it. Him and Harvey, they entered the property without my consent, and they were taking pictures, looking, inspecting. I don't think it's appropriate for anybody unless I get the consent to actually show up.
But we have an application before a board.
Right, but you cannot enter to a private property unless you call me and say, look, can we go and see it?
Well, let's not
No.
waste time on that, but we can have Mr. Hammond explain some
But
of
just
the.
another question, so, Mr. Robles, well, first of all, we have sympathy for you. You bought a property, you made an investment because you genuinely believed that it was a legal use, that it was legally non-conforming or whatever. So we have sympathy for you. But when you were here last time, the zoning official for the town, Jeremy, testified to the board that he didn't believe there was sufficient evidence to justify that it was legally non-conforming. That, said differently, that when zoning went into effect to ban family homes, that this was a 2-family home and operated that continuously up until now. And what we said to you, Mr. Robles, was please give him more information. Give him the title report, give him whatever you can. And it sounds like, have you given him anything additional? You said the title report doesn't say anything, but have you delivered it so we can at least see what it says? Or has there been any information provided?
No, Beatriz she's not here, she was supposed to be the one moving all around. All of a sudden, I have too many things on my plate. So
Understood.
Okay.
I didn't know what's happening until before I got here, half hour before. She says, well, I'm not going because I'm sick, I'm dying, whatever. So I don't know what happened. All I know is that I read the title report, and the title report doesn't say anything except the address.
It didn't say, the title report wouldn't just say the address, it's gonna say.
No, I mean, it doesn't say 2-family.
But does it say 1 family?
No, it doesn't say 1 family there.
What does it say? It has to say something, it has to say something about the zoning or something, it just says the address and mortgage and that's it?
I could bring him what I says, but again, I forward that to her, and she was the one supposedly.
Right.
Well, I mean, we could continue this and wait for other documents, but I think there are other people here who have some documents they can present as well, yes?
Sure.
Anything else you want to tell us? You're welcome to come back up, but maybe what we can do is ask for someone else to speak.
Okay.
Okay? Is there anyone else that would like to speak? Yes, please come up to the microphone
Yeah.
and state your full name and spell your last name for us.
Sure, Kyle Newman, Neumann. I'm Elvis's realtor. I sold him the property, so we inherited this together. And obviously, from the start, it was advertised to us as a multifamily on the MLS. I spoke to the listing agent regarding, where he got his information. Could he give us any other additional documents that we may not have? We did meet with zoning actually and did bring the title search. It didn't have anything additional that they didn't already have because it's the same source that the listing agent went off of is that the title company went off of, and there are 2 documents in the title search that, again, the search doesn't specify whether it's a single or whether it's a multi. They talk about the dimensions of the lot, the location, in Darien, but beyond that, the document that does say the 2-family that's included in the title search and also with the zoning office is that is the field card. Field card says that it's a 2-family home.
Did it show the 2 kitchens?
I honestly don't remember exactly. Field cards usually don't.
They show. They just kind of.
It should show there's 2 kitchens. At least in verbiage. It shouldn't as far as like an image or anything goes, but it should show that there's 2 kitchens in there. Other than that, it's the tax card. What I see on the MLS. Both say right there on the tax designation where it says zone. It says right there multifamily use.
Yeah.
Like right there as an agent.
I sympathize, I'm an agent, and our agents do this all the time. They
So-
just throw stuff up as a multifamily instead of doing the proper due diligence, so.
Well, it's pulling from the tax card, though.
Yep.
It's the so our sources with the listing agent, myself, and even the title company, they're all going off of your source, and your source is showing that it's a multifamily,
Okay.
which is really what's crippling us here. And the only thing that, because we did meet with the zoning department, and, you know, there's evidence here that this has been a multifamily since 1952, I believe is the year. There's field cards that do go back to 1952.
Okay.
That this has been a multi. The only thing that we're being told that arguments that is that there's a zoning map from 1948 that's showing single-family zone. Obviously, you know, we weren't alive to know why they allowed a multifamily to be built there, but, you know, they kind of went hand in hand. This property wasn't ever a single family then turned into a I mean, it was a multi. Let's see, other than that, if there's anything else I wanted to share. Yes, Beatrice unfortunately was sick and couldn't show up. But we did get a letter, as Elvis mentioned, so there is some additional documentation as far as, you know, affidavit as, you know, on the length of it to kind of just re-support that, you know, the use of this and what, you know, the bill of goods that's been sold to us. Are there any additional questions from you guys to me from a real estate perspective?
From a real estate perspective, have you considered making it a single family and either flipping it or renting it as a single family? That's a huge market in Darien.
Yeah, you know, on that note, you know, that's an interesting question. I mean, I can tell you right now, when Elvis bought this property, he was interested in the multifamily, right? And the owner, Jack, he refused to sell the multifamily without selling his single family in a package directly next to it, 41 Herman. That's the house that he grew up in. He wouldn't sell 35 without 41. And so Elvis went above and beyond. We spoke to the lender and did what we had to do to buy both of them. You know, I can't dictate why or why not he preferred a multifamily, and I can tell you right now, as far as an investment property goes, the return on a multi, you know, renting 2 units out versus the one single was a higher return with less risk. So maintaining that made more sense, and all he wanted to do was improve the quality of it. And from I think from a real estate perspective, and certainly you can relate, understanding the lack of, you know, whether you want to call it affordable housing or just housing in general. I mean, obviously we are in, you know, there's a massive issue in this, not Darien, but this country, you know, not this just state. There's no housing. New construction is an issue, and you know, forget housing that people can actually afford. So I think by sticking with this route, it was a win-win for everyone involved, including the future person living there.
Okay. Thank you.
Thanks.
Go ahead. Sure.
Thank you. My name is Andrea Halverson, and I live at 30 Edgewood Road. I am the neighbor right across from both of the properties.
Okay.
Could you spell your last name, please,
yes,
Andrea?
It's Halvorsen.
Thank you so much.
I just want to give you a little bit of the history of the properties from my perspective. I moved in 2016. There was an elderly gentleman in 41 Herman. It was my understanding, and I literally look right at their driveway. My children's bus stop is their driveway. It was being used only for a rental purpose for his caretaker. He had a home attendant with 2 children, and they were the only people who lived in that property for many years. The elderly gentleman passed away a couple years ago. He had 4 children, it's my understanding. They were all out of state, and nobody was maintaining the property. 41 was empty, and 35 became very full with people. And I placed a call to the zoning board at that time asking how the property was zoned, because I was worried about how many families were living in there. It's a very sharp corner right there. I don't know if you guys know that turn on Herman. It's a very sharp corner. I'm on Edgewood Road. It's an entirely residential area filled with many young children, and that corner is dangerous to begin with. And what happened when there were a lot of families living in 35 is that it's a very narrow driveway. You can only park single file in the driveway. So only one car would park in the driveway, and the rest of them would park around the corner. making a dangerous situation significantly worse. When I called zoning at that time, I was told it is zoned for one family and there should be no more than one family. And so at all times, there were at least 6, if not 8 cars coming in and out of that home that appeared to be residents who were living there. Shortly thereafter, it went on the market. I didn't make a big deal of it. I figured it would trade and that the issue would be resolved. Obviously, both properties traded. It's my understanding that the 2 properties were one lot and they were subdivided after the sale. They are building a gigantic house right on the corner. The builder told me it's going to be in excess of 5,500 square feet. It's not a big property to hold that type of house. The residents who were previously in the 2-family were parking in that single-family driveway because the house was vacant. There will be nowhere to house parking for 2 families on that now very small lot, considering that the adjoining lot is going to have a huge private home on it that will have its own driveway and its own occupants. So my concern, I know all of my neighbors share this concern. I believe that 31 Edgewood also submitted a letter, and possibly 28 Edgewood also. We are just worried that our crowded little corner cannot sustain a 2-family home that I know they want to make substantially bigger than it is currently. A bigger 2-family home will only mean more people living in there, more cars, and that tiny bit of space, I just don't think safely permits a build like that. I understand that it's not habitable right now. I mean, you when you go by, you can see, I think like one of the walls is completely off. You can see into the home. It is not habitable. A lot of work has definitely taken place there. Obviously, the owners of 35 and 41 are the same. I think there's a lot of cars constantly, and when they're not doing work there, I do think that perhaps they are in the 2-family home right now doing work. I understand there are no permits, and I have concerns about the safety of moving a 2-family, and I heard the realtor's concern about affordable housing. We are 1 block away from Allen O'Neill. There is a lot of affordable housing in this particular area of Darien. There's also Darien Commons, which is about to open hundreds of units. This particular tight corner just cannot fit it safely, and that's my feeling. So thank you very much.
Thank you.
Mm-hmm.
Hervé, please, come on up. Even though we know you, you've got to state your name.
Yes. Hervé Hammond, Zoning Enforcement Officer for the town of Darien. Thank you, all. I'm not going to go back to the whole history that I did last time because you heard it up. The big picture is I have done an extensive research in the building permit history of 35 Harmon. And the most compelling of the document is a certificate of occupancy that was issued in 2004 on October 22nd, signed by both building official Charles Severin and zoning enforcement officer at the time, David Keating, that states permissible use of and occupancy, single-family residence. And it's typed and it's part of the documents that you have had on this file from.
And just for clarification purposes, how would somebody obtain a copy of the certificate of occupancy?
It's available when you look into the building permit record.
Okay.
You can actually ask, you can go through the field cards as we were talking about. We exchanged and we made sure to share this information with Mr. Robles and his realtor when they came. And we shared it with the Zoning Board of Appeal last time. So.
Do you feel that the CO is the best indicator of what the property truly is?
So what I think is maybe different than, what I think happens is, in this case, the structure has been used as a 2-family residence since 1952 or 56. The first assessor's card that says 2-family in the corner is 1956. We know that's been the use, but we cannot find anywhere a legal document that says there was a permit that established that use. Now, if you look back at the original 1925 zoning regulation, there, and which I have a map of, that's a Zone A residence that allowed 5 family per acre as a maximum, if you want. The property at the time was 50 by 200 feet. There has been a lot line adjustment in 2003, but before that, it was 50 foot wide by 200 foot deep, which is allowing only a 10,000 square feet, allow only 1.14 family. So it was never designed, even back there in 1925, to accommodate more than one family per the size of the lot. So that's kind of the logic I use from the beginning of the case. It's like, okay, does this 2-family house belong in this neighborhood with the lot that it's on? So the 1925 regulation is telling me no. It's telling me the house should have been, and it's actually always referred to as either 2-story frame building. There's never an indication of a 2-family in any of the maps that I looked at, the 1946 map, the Sanborn map. None of the maps say 2-family. The only time you see the word 2-family is on the survey that was done, and you've seen it, when they did the lot line readjustment. And that's the 2003 document, which is filed with Land Record, and I don't deny that this document does exist. And on the building itself, it says 2-family dwelling. Existing 2-family dwelling. Now, this is a discussion I've had with my director and other people. A surveyor does not establish a zoning compliance. He goes and he observes. If he sees 2 meters, for him it's a 2-family house because he's there to have a sharp eye on everything that's existing. So he's seeing an existing 2-family. He's not questioning, is this legal or not? Now, go ahead. You have a question.
What was the date of that again?
It was recorded for file by the town clerk on July 1st, 2003.
That's the
That's
survey?
the one that shows the lot line adjustment. That's the survey.
And the 2004 CO was a response to some sort of permit application?
That's correct. There was a constructed 2-story addition to the dwelling in 2004. So
When
those documents.
When was the house first built?
So the house, there's no exact date of the building, but we know it happened sometimes between 1919 and 1928. The lot was vacant in 1919, and then it was converted between Austin to Marone with the house on 1920. That's in the deed record, which I have researched as well. But the house at the time was actually smaller, actually.
When you cited the 1 per 5 acres, what was the date that those regulations
So
went into
that's the
effect?
1925 zoning regulation, which we have a record of.
Okay.
Why is my paper falling all over the place? Anyway, that's the map. There it is, right there. We have a copy of this in the zoning office, and that's the original map that shows Herman Avenue. Herman Avenue was created fairly early on. It was part of the Hawes estate. The Hawes and Herman estate, which were created in the map was filed in 1909, so for the subdivision. So it's really kind of like original Darien zoning.
But we don't know whether the house was built prior to those 1925 regulations, right? We're not sure?
That's the beginning of zoning in Darien. So
Right, but we
yes.
don't know if the house predated it or.
We cannot find the
Right.
exact date.
So we don't know if
It could
prior
have been-
to
yes.
the zoning that would
You're
have
absolutely
prohibited a
correct.
2-family use, whether it was operating then as a 2-family use that would grandfather. And we have some evidence that over the century that has passed,
Right.
it did operate as a 2-family house, at
Correct.
least for some period of time. We know that from the field cards in the 50s, we know that from the survey in
Right.
03, but
The
we
2
don't know.
meters,
Right,
yep.
Right, we know.
So this is, the legality of this non-conforming use is one aspect of this case, which I find very interesting. The other part is, no matter how we look at it, it's a 2-family house in a single-family residence zone. The zone is R, 1/3 of an acre zone, and the reason I looked into this is because the permit that was filed asked for an addition to the house, so increasing the nonconformity and therefore requiring variance. So there's several aspects of this. And I don't know if well, I know that if you establish that it's an illegal nonconforming, that may change the end scenario. But even if it's established as a legal nonconforming, we're still going to talk about the variance of enlarging.
Right, so question one is, can we allow a variance at all? And we only can if it is a legal nonconforming.
Right.
And if we decide that it's legal nonconforming, then we still have to do an analysis about whether there's a hardship.
Correct.
And whether this is the minimum adjustment necessary, et cetera.
That's exactly right. Yeah.
Okay.
I totally agree with you. I don't think there's too much more to add. Do you understand why there, without an official piece of paper or something, it's just a continuous use? Not sure that it was before 1956, personally. I think that the house has been enlarged by Mr. Capocci over time and converted into a two-family. It's not designed, if you looked at the plan, it's not designed as a side-by-side or having a very good private entrance for one to the other. It looks like it's been chopped up, and I'm a 30-year registered architect, so Beatrice and I have talked about that, but it's not very conclusive that this was not changed up, and that kitchen upstairs, anyway. So
Okay,
currently the house is gutted.
yes.
Okay, there are no more kitchens in it. The kitchens are
Okay.
gone.
Yes,
So, I do want to address Mr. Robles' point about walking into the property. Once, and that's in the Connecticut General Statutes, once a building permit is filed, there is an obligation from the zoning official to confirm compliance or confirm what the permit is about is accurate. We were told that only the plaster had been removed from the wall. We went around, Mr. Woodside and myself went to the property, we walked around the property, we knocked on the front door. There were people working at 41. We waited, nobody came, the front door was open, wide open. Unlocked, wide open. So we had to double check the thing about the plaster to confirm the amount of work that was being done in the house. And we saw a good amount of framing. So we had to have a professional and accurate evaluation of the amount of work going on. We saw new electrical, so there was work that was done without a permit inside that house. And that's part of what we do as zoning enforcement, otherwise, right?
I get it.
We made sure to make ourselves known. We were around the house, we knocked, we waited, nobody was coming, but we have a
Okay.
permit application open. Okay,
Thank you.
okay.
Any questions before he steps down? You good? Woody? Quiet tonight, Matt. Okay, thank you very much. Does anyone else wish to be heard on this application?
Yeah, I just wanted to say one more thing.
Yes. Remind us of your name again, Mr. Newman?
Kyle Newman, and I totally respect and appreciate the safety concern. I would just think the issue with parking on the street is more of a street parking concern than, a dwelling in the neighborhood. And to be clear, 35 is not on the corner. 41 is the corner lot. 35 is next to that. But if there is a safety concern of cars on the road, I would suggest not allowing parking on the street in that neighborhood. But, no, sorry, that's it.
Thank you.
The only issue is with closing this is I don't think we heard from the applicant about the variance hardship issue.
We did not.
So if in fact, if we think the use
It's
is
illegal.
illegal, then we can close and make that determination. If we think otherwise, then we have to take further testimony.
Does anybody feel that they would know how to make that decision at this point, or should we go on?
I mean, I know, I think I'd be fine with closing and making
About
the determination.
Okay, good. All right, last chance? Okay, thank you. So 35 Herman Avenue is closed. We will deliberate on that later this evening. As for the public hearing, we are now going to calendar number 23-2022. I'll try and move this along quickly. This is the application of Nicholas Vitti and Martha Kalina on behalf of St. John's Roman Catholic Church to allow the construction of a mausoleum. My understanding is this is the first mausoleum ever in Darien at 25 Camp Avenue. Let's hear it.
Madam Chair, if you just give me a moment to set up my.
It's exciting stuff. Oh, I know it, yeah. Okay. You know what, that's not funny. I'll tell you about that. I have to have all conversations on the record, right? I shouldn't be whispering?
Well, it's just between you and me.
Okay, that's fine. Make sure you're not yelling at me.
I keep secrets.
We're off the record right now.
I have driven by, I do Zumba in the area, I drive past that place all the time.
Currently involved in a freedom of information.
Oh, I'm sorry. Yeah, if you're gonna, you need to be by the microphone. And if you're gonna be over here, you need to bring the mic with you, okay? Thank you.
Shall I bring the whole of the stanchion or?
No, it pulls right out. You have 20 feet to play in.
Do you have dancers coming as well? Or is this
Singers,
just
backup.
a straight presentation?
Yeah, here's backup.
We do like to get out of here before 11, you good?
I'll try to hurry it up.
Thank you. And when you're ready, I'll just have you step to the microphone and state your name.
Good evening, Madam Chair, members of the board. Thank you for your time this evening. For the record, Nicholas Vitti, spelled V as in Victor, I-T-T-I, same as the building official, from Merthyr Kalina. And I'm here representing the applicant, St. John's Roman Catholic Church, who is the owner of the property at 25 Camp Avenue, commonly known as St. John's Cemetery. Just for some introductory purposes, with me this evening is members of my development team, Mr. Joseph McCurdy, who is the Director of Operations for the Diocese Cemetery Associations, Mr. Brian Smith, who is our project engineer. He's from Rocco v. D'Andrea. Kevin Fisher from Northeast Mausoleum, who's our contractor on the project. And Mr. David Wilson, who is our architect. He is actually out of state, but available by phone in case we have any questions for him. To start, we're here before you and excited to be here before you. This is the culmination of many months of planning, many meetings with virtually all land use staff within the town of Darien. The request before the ZBA this evening is for a variance of 3 regulation sections. Regulation sections 406, which covers building height in a residential zone, in our 1/3 zone. Regulation 906.6, which is a variance of the parking setback off the street frontage of Camp Avenue. And regulation section 944, which is a variance request of the landscape buffer associated with the parking, which is geared more towards a residential setting. These variants, if approved by the board, would be the first step in the process, but would allow us to proceed on the construction of a new state-of-the-art mausoleum and maintenance building, because it would house both, at the St. John's Cemetery. And this would ensure the longevity and maintenance of the cemetery into the future. For the record, I note that 38 notices were mailed out to abutting landowners. Out of the 38 total notices, I did receive an email and had a discussion with one neighbor who lives off Hoyt Street. Explained the project, did not did not understand that he had any objection with the proposal, but he thought that it might be nice if we included in this development some tree lining along Hoyt Street, which is a bit further away from the actual project and construction site. We agreed to continue the conversation, and that might be a very good idea as we go through the planning and zoning review process, if you indeed approve these variances. Also for the record, I know that there are a couple of referral comments, one from Mr. Rick Talamelli in the record, who comments on behalf of the EPC and has no objections to the variance requested. He does have some recommendations if the project proceeds through planning and zoning, and we will address and accommodate all those recommendations. Your staff, Mr. Woody Woodside, has also posed some questions to the applicant as of late last week. And I have responded via written memorandum. I know that it was only recently filed, so I don't know if it was disseminated as a part of your paper packets. If it was not, I do have a copy for the board, but it's definitely a part of the record and is also filed online.
I think we have that. Is that what we have? This to Jeremy Ginsburg dated
No.
January 12th of 2023?
No, this was a memorandum dated January 16th, 2023.
Okay,
Woody sent it yesterday, I think.
Oh,
right?
yeah.
Oh, I'm sorry, we did. You emailed it. Okay.
I read it.
I appreciate that.
If
We do
anyone
have
would
it.
like a paper copy, please let me know and I
Okay.
can certainly provide
I
it.
think we received it Tuesday.
Okay, I think we're good. I don't have a hard printed copy, but yes, we also have it. Good. Okay.
So just on a little bit of site orientation. This is the site, 25 Camp Avenue. Doesn't even show the whole of the cemetery proper. This is only a very small, well, about half the portion of the total 35.65 plus or minus acres at the site. We're located in the northwestern area of Darien, and the cemetery is very close to the Stanford border, if not almost adjacent. We're at the corner, obviously, of Camp Avenue and Hoyt Street, so we're a corner lot, technically, in, again, a residential zoning district, the R1 3rd district. The proposed construction is right here, off of Camp Avenue. Right now, currently, there exists a dated, old office house-type looking structure that does house a current maintenance building and also offices for a couple employees of the cemetery.
I don't want to throw off your wind here, but is there a reason why, other than the fact that there's a structure there, is there a reason why you're putting the new building, you're proposing to put the new building in that location?
Yes.
Okay, you're going to get to that.
Definitely, but I can answer the question now if it's on your mind.
I like to get to the meat of it.
Yes. I'll flesh out this a little bit more, but in the immediate, the answer to the question is, you see all these dots, these gray dots, they're kind of out of resolution. Those are all grave sites. This cemetery is completely at capacity. There's only a few burial plots left in the whole of the 35.65 acres. And this is the only area where it can be placed. Mass relocation of grave sites is simply not an option. There are some other factors that go into the equation, but that really is the essence of why it would be located right here. Take away an existing non-conforming structure and replace it with the mausoleum site.
And will you, in this proposed plan, will you be relocating some of the graves?
A couple.
A couple?
A couple.
What's a couple to you?
And I can have my client confirm the actual number, Joe McCurdy, but
Okay.
I mean less than 5.
Okay, got it.
Less than what?
Less than 5.
Okay,
Okay, but some other factors that contribute just to this site's location. I mean, this is where a structure currently exists. We do have the Norotan River adjacent to the site, which creates building on the site, even if mass relocation of grave sites were an option. an issue. We have the Metro North Railroad tracks that bisect this area. You're on a corner lot. The site is, even though 35.65, it's a bit compromised, and really this is the only location where this proposed mausoleum can go.
Is that building on the cemetery's building in the bottom of the
This
Google
here?
map view? Yep.
Yes, that is the cemetery's building as well. That's an existing mausoleum. And within your packets, there is a picture of the interior of that mausoleum. I will say and offer for the record that what is proposed and detailed in the renderings is, this was built a while ago, and it's still pretty spectacular in terms of its monumental and ornamental decorations.
Is it this, Mr. Vitti?
Yes.
This is the lovely existing mausoleum. And are you preserving anything of that existing building?
No.
So you would level that thing completely and start from scratch?
Correct.
Foundation, everything?
Yep, that would
Okay.
be the plan.
Okay?
What's the existing square footage of the building that's there today?
I'd have to check the field card. Not sure off the top of my head. I would have to get back to you on that. It's smaller than what's proposed, obviously, though.
What's the size of the proposed? Do you know offhand? I know it's in here.
20,765 square feet.
20,760 square feet.
Correct?
Okay. Is there a reason for that? Are you trying to max out something, or maybe that's small for a mausoleum? I don't know.
No, I mean, the idea behind the size is there's been careful studies and business plan, and what we're trying to do here is maximize the longevity of the site. With no burial plots left, calculations have been made how many, and I can discuss what is a mausoleum itself, but how many crypts, niches are needed, and also the maintenance needs. And that goes into the size. So a reduction in the size would compromise the viability of the project, in essence.
Okay. Is there a crematory on site?
No.
Okay.
None of those services are done on site. This is just an entombment site. So much like the cemetery itself,
Okay.
All outside crematory activities are done somewhere else.
Okay. And I know you're going to address parking as part of this. That's an issue for us as well. So we're going to get into that, or should we jump to that?
However you like,
Okay.
Madam Chair.
I shouldn't be jumping around too much. Okay, good. Keep going. Keep going.
No, we can definitely address parking if that's at the top of mind. I don't mind addressing it, and then I'll try to splinter through my outline to see what
Okay.
I've covered already and not.
Okay, why don't you continue with the hardship of the lot? You started with that.
Sure. So there's hardship here, and again, I have mentioned some of the factors just in describing the parcel itself. But we believe that there's hardship on several different grounds. One of which, this is a non-residential use in a residential zone. That's very out of the ordinary for a Darien parcel. You've got an R1/3 zone. One-third of an acre is roughly just under 15,000 square feet. You've got 36 acres here. It's a very different parcel, wherein the R1/3 zoning regulations do not properly accommodate for this site. They're simply written for small residential parcels, and here we predate zoning and have a massive parcel. We don't know the exact date of the cemetery, but there are graves that date definitely back to the 1800s.
Okay.
So we've been here for a while, and our intention is to stay into the future. Other than that, we're on a corner lot. We obviously have to accommodate frontage concerns on two road frontages. We're adjacent to the Norotan River, which creates complications, having a body of water in the vicinity. And we're bisected by the railroad tracks. Another hardship is the extreme limitation on where this mausoleum can be placed. And as I already pointed out, there are graves everywhere, and they cannot be relocated or mass relocated. We're talking about less than a handful or a handful. And in conjunction with the railroad tracks that bisect the property, And I don't know if anyone's had a chance to actually visit. You said you drive by almost every day. The subject area site is a severe slope. The existing building and where we're proposing the new building would be located in kind of this bowl where you're coming off Camp Avenue and you have a significant slope, a 10-foot elevation drop. And we're proposing to be built into that hill. That in and of itself creates a topographical hardship because the height calculation is implicated. The way we measure height and an average grade calculation makes building on a sloped lot more difficult to comply with the height regulations in the zoning district, the 30 feet. In addition, we are located in a floodplain. I can have my project engineer speak to the actual flooding that would occur, which we've had discussions, and I'm not going to belabor this with this board on whether or not this is really a flood-prone area. But the fact of the matter is, we are in a floodplain, so we need to raise the grade above the BFE, the base flood elevation, so that raises the structure in and of itself.
Do you happen to know which flood zone you're in?
I believe it's AE.
Correct.
Now that you've said that, I have no idea what that means. Is that like a 100-year flood zone? Is that?
Yes, and if Brian Smith, our project engineer, could probably get more into the definition.
Just want to go on the record as to what it is. That helps.
Sure,
You
Brian.
can come up later, whatever works for you guys.
Okay. The culmination of all those things and factors that I just went through are really what we propose is the unusual hardship at the site. This is a site unlike any other in the town. The size, the use, how long it's been in existence, and the limitations both in the subject area, having the slope you're not creating any precedential value here by approving any requested variances. We talked about, or you mentioned parking, so why don't I address that right now. What we're proposing, so currently, and you can kind of see on the plans, there's no parking lot there. So all parking for this office and maintenance building is street parking. We're proposing what we believe to be a better solution to that.
Street parking, where do they park right now on the street there?
It's a carve-out. It's like
The
3
picture
spots.
that you're holding up kind of details what the existing is. And it's a problem. It's street parking on Camp Avenue.
Well, who's using this building? Are they having celebrations or?
No. The building use now is staff and maintenance. Maintenance is not parking there, but there are 1 to 2 employees, office staff, who are using the building currently and would be using the proposed building if approved and constructed.
Because typically, based on the size of the building, we need to see so many parking spaces. But I have a feeling in a mausoleum, there's not a lot of people, there may be a lot of storage.
So I've actually gone through this in other towns in bringing applications. And one comment that I never forget, this was on a self-storage, and not to get too divergent off the topic. Self-storage is a very passive use. A staff member in the city of Stamford said, it's probably the most passive use other than a cemetery use, because cemetery use is the most passive use from an automobile standpoint, from an activity standpoint. Family members will come to visit tombs, or crypts or niches, but it's intermittently, and it's nominal at best.
And are there visiting hours?
Yes.
Okay.
Those are strictly normal business hours, 8 to 5.
Okay.
At 5 o'clock, the mausoleum goes dark. There's no exterior lighting planned or proposed. That's purposeful. The cemetery goes dark with the mausoleum as well.
Okay.
I don't know if this is the right term, but on the day of an internment, I presume there will be a significant amount of vehicles. And what is the plan to handle that? Is it just park on the roads in
Nope.
the cemetery, or?
Oh, yes, I didn't let you finish, I'm sorry about that. So the plan is no different than the plan today, and at most cemeteries you will see. Most cemeteries you'll find do not have surface parking lot. Real estate is valuable for a cemetery because that is burial plots. But they all do have interior roadways. So on an interment, what would happen, and I apologize that this aerial doesn't show it completely, the main entrance to the cemetery, there's no entrance to the cemetery up off Camp Ave. The main entrance is a little further below here on Hoyt Street. So you would turn into the main entrance, and then depending upon where the burial plot is located, the cars would park along the interior roadways. That's the only way of handling the parking on the cemetery. And it's done intermittently, sparingly at best, when there are actually funeral services. That same setup would be for the mausoleum itself. They would come in off Hoyt Street, use this interior roadway, and park along the interior roadway.
So no expansion or change of the current pathways?
No.
Roads, okay.
And this is a mausoleum, not a columbarium, is that right?
This is a mausoleum and a columbarium, actually. So
how many total bodies / ashes would be?
I can get you the actual numbers, and they're on my architectural plans. But let me just, while you raise that point. So a mausoleum, oh no, that's that, sorry. So crypt spaces. So a total between crypt and niches are 2,162 spaces. A mausoleum houses the remains of full bodies in kind of vault-like structures. That's what's called a crypt. A columbarium, on the other hand, houses cremated remains, usually in an urn or some sort of container. That's the only difference. Here, we're proposing both uses.
So can I ask a threshold question? I'm pretty sure town zoning regulations allow, through a special permit, a columbarium, but I'm pretty sure that a mausoleum is not contemplated anywhere in Darien zoning regulations.
And that's a very good question.
So we're prohibited as the zoning board of appeals from granting a variance that would allow a use that's not otherwise allowed in the town. So why are you before us now and not before the planning board?
The plan, as it was planned out with staff and with meetings with staff, was to proceed with the variance request first on the contemplation, and it could be conditioned upon the fact that the regulations would be changed. The R1/3 regulations allow currently a columbarium as an accessory use to the cemetery use.
Right.
Overall, it's a special permit process. We met with Jeremy Ginsburg and Fred Donnet months ago now, when we originally proposed this. And part of our proposal was to piggyback upon that columbarium use being a permitted accessory use, and have a very simple regulation change that simply adds the word mausoleum.
So your plan, your requirement is to go to the planning board and amend the zoning regulations to permit a mausoleum use in the town of Darien? And then specifically in a residential district via a special permit?
Yes, but it would only be in conjunction with a cemetery use. You couldn't just
Right.
have a mausoleum in a residential district.
Right.
It's only in conjunction with either a
Okay.
church or cemetery.
Okay, so I mean, if and when we get to that, I think if we granted approval, would be conditioned on the town regulations being amended to allow this use, because we couldn't otherwise.
Correct.
So then, get past that threshold issue, why is this, and assume we buy the hardship, but that this is a unique parcel, which I think it is, and then there's a hardship, why is this the minimum adjustment necessary? Why do you need 2,162 spaces why do you need 40-foot tall structure? Why is this the absolute bare minimum that you need to have the justice in the use of your land as is required?
This provides for a reasonable longevity of the use. Anything less will simply have the cemetery closed in a shorter period of time. That's in terms of crypt spaces, niche spaces itself. On the height, there are certain height limitations also attributed to the maintenance building, where the ceiling heights are bigger here. We need to be able to store certain machinery and equipment and an interior lift structure that would also contribute to the height.
So a lift, your lift structure, equipment, whatever, requires a 40-foot ceiling and can't go any lower?
No,
40-foot
so the
means
40-foot ceiling is a bit of a misnomer as well. There's different structures and different heights, and I can display that.
And I would just, as you go ahead and do that, or just proceed with just the general knowledge that this board, I don't think ever has allowed a variance to go above our standard height regulations, absent there being some significant sloping issue that you had to start counting from down too low, and would be concerned about it in this instance and allowing that to go forward.
Yeah, and I would offer that those circumstances are present here. In addition and I understand your concerns. Height variances are not something that I would generally counsel a client to seek. I think this is a different parcel, a different structure. And just if I can explain the differences in heights. If you're looking at this, because it's being built into a severe slope off Camp Avenue, the flat portion of the roof is actually lower than the 30-foot minimum or maximum requirement. Because of the average grade calculation, as you get further back, the height of the flat roof starts to go over the 35 feet. So you have almost compliance on certain sides, but non-compliance on others. The 42 feet requested is only for this pitched portion of the roof. And you can see this is a rendering off of Camp Avenue. The pitched portion of the roof is going to be set back on the part of the building. And its purpose is one in which it hides mechanicals and creates a church-like aesthetic. Rather than having a flat roof with the mechanicals shown, essentially that pitch is covering those and providing a better structure. And that's, I think, important because the renderings don't do the slope justice in my estimation, and I think it's hard to do on a computer. But if you're sitting at Camp Avenue, or even for that matter, on Hoyt Street, you're at higher elevation than where this structure is going to be built. So,
But is it really a severe slope? I mean, we all
Yes.
drive by, it doesn't seem severe to me.
if you step out of your car and walk down, I mean, it's a significant slope, especially from a building perspective.
From the top of the high point to the bottom of the low point,
Yeah.
what is that dimension?
And Brian, the dimension from the top to the bottom. I mean, I think there's at
Of the
least-
slope.
Yeah, I believe there's at least a 10-foot drop in slope.
And while he's looking at that, is the flat roof compliant, or that is also part of the variance?
Portions of it are, portions of it are not. Certain sides are, certain sides are not. For instance, the highest side of the flat roof to the surface of the roof is measured 35, 4.5. So we're 4.5 feet over.
We're gonna ask you a tough question. We always try and go for this. How much are you really asking for? So if 30 feet is what we seek, and you said part of it is over, and part of it's at 40 feet, but there's a drop off, do you know the volume that you're really asking for?
It's
Not the whole roof, it's 60% of the roof?
I don't know if I can estimate
Okay.
that. It's It's the rear portion of the mausoleum building. Everything on the frontage off camp would be compliant with the flat roof.
Okay.
But the rear portion, as it slopes into the interior of the site, is where you run into problems with that.
Okay. Okay, and even though it's 40 feet, because of the drop-off, it may be just a little higher than 30, but we're gonna hear from
Yes.
Brian.
Yes. Brian, do you wanna?
For the record, Brian Smith, Smith, with Rockwell with DeAndrea Surveying and Engineering, PC. About the building height and pre-existing topographic situation, when we calculate the pre-existing elevation, we drop the building right into the site as if we were going to do no grading whatsoever. Because of the slope from Camp Avenue into the site, we have a pre-existing average elevation of 73.45, so I'll call it 73.5. The issue is, in the regulations, we're only allowed to add 12 inches to that pre-existing number. We're in a flood zone of AE 76, meaning that FEMA has mapped flooding to elevation 76 in this area. To conform with FEMA flood regulations, we want to raise our floor 12 inches minimum from the 76 to elevation 77. Now we've already created a difference from 77 to 73.5 that's working against us. The fact is, we're going to be feathering up the grade so that we can have ADA compliant walkways into the building, and just have navigation around the building, foot traffic, driving drop off of the casket that's sensible within code. So that 3.5 difference between what we're calling our proposed average grade and our first floor is already, it's working against us. By the time we add, we set our floor at 77 and then have the enlarged 2 stories, this is how we're kind of adding to the cake and raising our elevation. So it's not, we would like to have code compliant height, but due to regulation on and definition of proposed average grade, as well as getting into FEMA compliance, that's where we're kind of compounding and had to come in for the variance.
This is a big structure. So I don't have any experience with mausoleums, but typically when someone comes to us for a house and they ask for something like this, we go, why are you building a big house? And they say, well, we want to max it out. We want to live in this house forever. It makes economic sense. But the economics are not a valid hardship for our board. So I understand you want to max this out and get the most life out of this project. You guys know where I'm going with this?
And what does that mean? How long is 2,162 spaces last, based on average projections?
It depends, obviously, on deaths and who comes to the site, but an estimate would be 15 to 20 years additional life.
Does it not make sense to do this unless you do it at this scale?
Yeah. Unfortunately, the answer is yes.
Because there's simple options to get the height back down, right? It's taking some of those rows and instead of having 14-foot ceilings in there.
Other than the maintenance area on the first floor, there could be, but there is some height limitations for that. And I will say, Brian went over well the technical aspects of the height. Put us on a flat site with no flood zone, and we might not have any issue. Maybe still with the pitched roof. But on the flat roofs, there likely wouldn't be an issue.
I think the site works to your advantage in this case. It's like you're getting all this extra volume because of the pitch.
Yeah, and quite honestly, from a vantage point and an optics standpoint from the surrounding neighborhood, it's going to be a lot lower than what's perceived when we're just talking numbers.
Be a lot higher than what's there, though.
What is the existing height of there's already a garage structure in the back where I presume the maintenance equipment is currently housed. What is the height
It's
of?
only 1 floor from Camp Avenue. It's much lower on the bottom.
I'm sorry, you can't, you have to come to the microphone. to
Or
speak.
he can answer.
Or you can answer.
That's correct. That's correct. It's 1 floor off camp, and then there's like almost like a
So is it like a 12 feet high garage, or is it, I mean, it looks higher than that, just visually.
Yeah, it is higher than, I would say it's higher than 12 feet. I don't know the exact dimension of the existing garage, but I would estimate, and I walked the site on numerous occasions, that it's more than 12 feet.
Okay, and then that houses the existing maintenance equipment?
Yes, and if you drive by, some maintenance equipment is unfortunately outside. You know, trailers and things of that nature are outside as well. We're trying to rectify that situation by housing everything on the interior.
So we always like to hear that. Are you getting rid of something that's an eyesore? Are you eliminating any buildings, cleaning anything up?
Yes, yes. I mean, I would offer that the existing building is an eyesore in and of itself, and it is non-conforming as to the front yard setback. So we are actually pushing the new building back a bit, so as we're conforming to the front yard setback, there's other issues with the parking setback that we're requesting a variance for. But this provides more conformance than what's currently there.
Okay. Sounds like you want to say something, Brian.
I just want to add for the record, the existing garage slab that's there now at the maintenance structure is at elevation 72.7. So that's 4.3 feet lower than our proposed slab, which would be in FEMA conformance. So again, I know it's hard, but if you can visualize a 3.5 to 4 foot bump up from existing conditions now to propose in order to conform with FEMA, that's the reason why we're going up.
So take us through the request. The variance requests are?
The variance request is the height itself.
Okay.
And we've listed the 42 as the max needed. It may be a couple inches under that or even a foot under that, but 42 feet, there's some difficulty in measuring to the pitched roof, not to the flat structure of the roof, but 42, we would stipulate that 42 is the absolute maximum allowed for that pitched roof structure.
Okay.
That's the height variance. The other variances relate to the parking this is just a zoning location survey done by Brian's office. So currently, as I stated, and this could be, in my estimation, an improvement as well to the existing site, because currently, parking is just street parking on Camp Avenue. So what we're proposing is this small parking lot. Remember that there's going to be 2 employees and an office, and 2 offices at the mausoleum in addition. So we're proposing this small parking lot off camp, get the street parking taken away. There's 4 spots currently there, with 1 being ADA compliant and handicapped, and the other spaces being driven by the employees there on a daily basis.
So 6 spaces in total, 1 ADA?
4 spaces in total, one handicap space is proposed on the plans.
Of the 4, so 4
Yes.
total, okay.
And to do that.
One of those spaces is down below, though. There's just 3 up on Camp Avenue, correct?
Oh, sorry, Brian, okay, so we have 2 handicap and 1 below and then 2 up.
If you don't mind, let's get into this, because we did ask for some help with another facility in Trumbull. There's about 12 parking spaces in front of that mausoleum. That's a much, much, much smaller building. So where would visitors park who are coming here to provide some flowers for their loved ones and such, or to meet in the office, for instance?
So currently, they would pull down and go to the mausoleum site and park along the interior roads.
And then go in the building to meet with staff?
Yes, unless if you're handicapped and there's a spot open here. There wouldn't be open spaces up on this parking lot, as there are 2 employees there and they each drive.
So then the question is, why is the office up there instead of down below, where it might be more convenient for visitors? Why is the office proposed where it is?
I would have to ask the client and the business people, the contractor that designed that. But the intention is not to have traffic on Camp Avenue. I mean, if there's a space open and someone pulls into it, then maybe that's a different story. But there are.
And why not have no office up there? Do it all down below. No office up there. Do it all down below. Just seems
Well,
goofy.
the maintenance building is down below, and this goes into the overall design of the structure itself. It's consistent with where the office is now, and you have employee parking up off campus.
And visitors meet with office staff now, parking along Camp Avenue.
Correct. Right now, they
Why
park
wouldn't they in
along
the
Camp
future?
Avenue. But what we're also proposing is a median strip here that would be landscaped with shade trees on the other side, which would prohibit parking on Camp Avenue.
Why couldn't you put more parking along Camp closer to like?
Gravesite.
To the right of where you.
The dash line here is a limit of headstone and footstones. As you can see, that line practically goes right up to the metal fence line along Camp Avenue. So within our property, we wouldn't have availability to add more parking there.
Because there are current graves there?
Correct.
But you are gonna move some, aren't you?
We're,
5, 4.
yeah, under about 5.
And those, I don't have the microphone, but those have already been planned and families consulted.
And is that the same reason why you couldn't make the building shorter and longer coming down this way? Coming to the south?
Yeah, that's the main reason why.
So you're saying, so we're clear, you don't want to make this smaller. You could, but it wouldn't make sense if you did.
The smaller it goes, the less viable it becomes.
Okay. It has to be where it is because of graves and where they exist. And other than that, that's really the only reason, right? There's no septic system or any other reason?
No.
Okay.
And I guess talk to us about the third variance in terms of
Yes.
landscape buffering or whatever you.
So, the parking off camp, there's in a residential zone, which technically we're in, non-residential use in a residential zone, there's a 25-foot setback for parking, so we're asking for a variance of that parking setback. We're also asking for a variance of section 944 of the regulations, which requires a 25-foot landscape buffer, or a buffer area where no parking would be allowed. If you take a look across the street, the only property that would really directly be looking from Camp Avenue onto this new proposed construction is a commercial operation. It's a garden and nursery. And it's actually in a business zone, a small business zone, service business zone, correct. Right across the street, they have a 6-foot parking setback. This is really not a residential setting in the area. I mean, different if you're talking further down Hoyt Street or in other areas. But where the project site is happening, you have railroad tracks on one side and a commercial garden and a business zone to the north. The buffer is intended solely to protect against intrusions from light, noise, to residential dwellings. The regulations actually say that specifically. There's none of that happening at play here. There will be no intrusion of light. This is not a lighted facility. No intrusion on the employees' autos parking there. Business hours are done at 5 p.m. It does not make sense from this use, this site, to apply those regulations and not allow this structured parking for the employees' use.
And earlier you said that the neighbor reached out and asked about, if we asked you to put in some landscaping, would you do that as part of the plan?
Yes, we have a landscape plan in. That's a matter of record here, and will be fleshed out before ARB. I have had a preliminary meeting with Architectural Review Board and Madam Chair there. So that's going to be fleshed out a little bit more. What I was speaking to, and we are long-winded answer of saying yes, we are willing to talk with neighbors, talk with staff, talk with ARB, and discuss additional landscaping if needed, or if you would want to keep more of the scenic rolling hills, natural landscape, combination of both.
I love your approach. We love when you're working with the committees of the town. That's lovely.
That's how I counsel my clients always. It's
Smart.
Tough. It's tough otherwise. Very tough otherwise.
Which neighbors are we referring to? Are they on the east side of Hoyt Street or?
Yes, so they are on the east side of Hoyt Street, a little further down. I believe it was 231 Hoyt who wrote me an email.
Okay, but besides that, have they all been supportive or?
Besides that, I haven't heard from any neighbors.
Okay.
Although in my notice,
But they have been notified?
no, they have been notified, yes.
Okay.
Yes, the original certificate of mailings is in the record.
Just curious, does this have to go through any MTA review, being close to the tracks there?
I don't know that it does.
My office has researched any requirements to go through MTA. We've not been able to put our finger on any regulation. I've heard a couple different 30 feet from a train track, 10 feet from a property line that abuts a train track. I've looked into this, I've put calls into MTA, I've not heard back yet, but I've not also been able to find any regulation that we have to abide by at this.
How close is it to the track?
We're 10 feet off the property line with the building. From the train track itself, it would be at least 30 feet, it would be 30 feet plus.
So it's unlikely to be an issue.
I mean, MTA is notoriously difficult to work with and build near, so I don't know.
It's a good question. Anything else for us?
Let me just run through my notes to make sure I didn't miss anything because I was talking mostly off the cuff.
And Brian, just quickly while he's looking through that, because this is obviously a key part of the hardship argument. The slope, right? So the top of the slope to the bottom of the slope. I know we didn't really get that. What is that slope? 6 feet, 7 feet, 8 feet? Because it really does not look that bad from Camp Avenue.
Yeah, Camp Avenue, we're about 84.
Okay.
And around the existing building, about 70, but I'd say 72.7 was the back slab.
10.
So 10, but now we'd be going 84 to about 77, 76.5 around the perimeter of the building.
And the 42-foot measurement, is that from the lowest to the highest point? What exactly, was that the average?
It's just the midpoint.
Yeah,
So the 42 is from our proposed average grade, which is pre-existing average grade plus 12 inches. Remember,
Right.
we're 3.5 feet
That's
lower.
the 73 number.
To the midpoint of the sloped roof is the 42.
Okay.
Am I correct?
Correct.
Okay.
And that's in the definition of building height within the regulations.
Okay. So we could make you knock it down in height, but then it would take away this beautiful pitch, which is more for cosmetic reasons, design.
Cosmetic design and
Could you
and
give the
hiding them.
microphone, please? Thank you.
Cosmetic design and hiding the mechanicals.
Hiding the mechanicals,
Yeah,
okay.
this is non-usable space up
Okay.
there on the pitch.
Okay. It's 9:40, we're gonna keep it moving. If you guys are
I'm
good.
Well, just
Um,
before you close.
Yeah, I'm not gonna close those to see if anybody else wanted to talk. Okay, oh, sorry.
Go
Go
ahead.
ahead.
No,
Why don't you talk?
no, go ahead.
Anybody else wish to be heard? I see you. Come on up to the microphone. Thank you, Mr. Beatty.
You're quite welcome.
You can come back if we have more questions, but, or if you have more comments.
I'd like to.
Okay.
Good evening. My name is Nick Gogarty. I'm the random neighbor on Hoyt Street.
He appears. Could you
Yes,
please spell your
exactly.
name for the record, Mr.
Caveat
Gogarty?
emptor, I'm also a father to an 8-year-old girl, so you'll hear a bad dad joke, and a cultural anthropologist and do a bunch of things in hedge funds.
Could you spell your last name, please?
Gogarty, Gogerty.
Thank you.
So, interesting, new building going up. We live on Hoyt Street, which is across and on the county road, so quite active. I told my 8-year-old daughter, new mausoleum going up, people are dying to get in there. That's the dad joke. The observations, a couple interesting questions. One, there's an old machine shed there that has a very high ceiling to allow for excavators and backhoes effectively to go in, so you can plan them faster in and out. Culturally, the reason that you see the separation between the offices upstairs and downstairs, literally it's culture, it's an upstairs-downstairs culture, right? So you have the office management people, et cetera, and then there are literally the guys who go out and dig the holes in the ground, and so they're separate functions. They may even been kept in the mausoleum separate. That's a spatial design and cultural issue. Just some background. I jog in the cemetery every once in a while. My only request is that over the years, the tree line along Hoyt Street has been allowed to kind of just atrophy and disappear. And I don't know the rationale or reason behind the original height requirement or the need for the variance, et cetera, why it's there, but it would be nice to soften the visibility and, frankly, the impact of the large parcel of land itself with what's typically what would be called an alley of trees. Now, an alley of trees is 2 lines of trees. Obviously, we can't have, you've got the other side of the road with the power lines on it, but putting in a line of trees on the Hoyt side street, which does not have power lines above it, would make the cemetery much more, I think, appealing. It would soften it up as a very large parcel on a fairly active road, and would kind of soften the impact of the proposed structure. So that's really all I have to add.
Is your home up on, there are a couple homes.
It's not high. It's actually on the ground. Okay. Let's say ground floor. So our perception may be very different from those who are higher up and back up on the hill. That's it.
We appreciate you speaking.
Sure.
So you're in support, so for the record, you're in support of it. If they were to soften it with some trees, that would be lovely.
If they could soften it with some trees, and obviously not going to put 20, 30-foot trees in, but maybe something that was, of a reasonable maturity so that it, would maybe be like a 10-foot trees or something along Hoyt Street.
Good. All right. Next.
Yep. So my name's Ann Rush.
Come up to the microphone, please.
My name is Ann Rush. The last name's R-U-S-H-E.
Thank you.
And I live at 241 Hoyt Street, so I'm actually closer, directly across from where the mausoleum is being built. Our driveway goes right out directly across where the mausoleum is being built. I think the current structure that's there, I don't know for sure, but I would say it's like 2,000 or 3,000 square feet. This is a 20,000 square foot structure. It's very, very large. I have concerns about the traffic on Hoyt Street. I don't know if any of you have driven down Hoyt Street between 3:30 and 6 o'clock, but you cannot make that left turn onto Camp. And putting this big structure there and then having cars coming in and out, I think is going to be like a concern for me and my husband. I think that between the 3:30 and 6 o'clock time, there are times when the cars actually, the end of the car line is at this middle entrance of the cemetery. There's another entrance that's closer to your house. Yeah. And that's an entrance that's closer to Camp Avenue. I don't know what you're doing with that entrance, but I have concerns about people using that entrance to get to that mausoleum. Because there is another mausoleum in the cemetery in the way back, and people enter through the middle section. Sorry. They enter through the middle section. So I do have concerns about the size of the building and the traffic pattern on Hoyt Street, and that other driveway that's going to be directly closer to the mausoleum, and how people are going to get in and out of there with the extent of the traffic that's on Hoyt Street.
Okay.
And the height of the building is also a concern in a residential area.
Mr. Vitti, do you want to respond?
I would like to, Madam Chair. As stated before, I mean, we're happy to work with any neighbors as we move through the application process, should we receive approval of these variance requests. Some of the things I just noted from the comments, in terms of cars, we're not adding any more cars. I mean, I know it's tough to say when you're considering 2,167 crypts niches. This, when you think about it, it really is the most passive use you can have at a site. Go to the cemetery, jog through the cemetery. You don't see people. Yeah.
Is there something to the traffic pattern that could change that would be safer?
If there is, we can definitely work with neighborhood suggestions, possibly by providing some wayfaring signs, and I think that should be fleshed out within the planning and zoning review process, and we'd be happy to continue that discussion.
Have you done a traffic analysis of any kind?
We have not, and quite honestly, the plan was not to, because you talk to any traffic engineer, including staff, I mean, this really is the most passive use going. This would be a position where, and I don't know if we've had, I think I have email confirmation from Jeremy Ginsburg, but I would clarify with him that there would be a waiver of a traffic study for this type of use.
And in your estimation, the street parking on Camp Avenue currently would be reduced?
Go away.
It would go away. I mean, that's the plan.
I love that. Good question. Does somebody want to speak? I hear somebody in the back and I can't see you over the boards.
Yes, this is a member of my development team, Mr. Joe McCurdy.
Hello, Joe McCurdy. Nice to meet you. MCCUR, D as in David, Y. I just wanted to alert you that as far as the interments go, we start at 7 a.m. Most of the interments, mass start at 9 to 10. The interments start at the cemetery, give or take, at 10, 11, and 12. By 3:30, all the field workers are gone.
I'm sorry, I don't understand what that means. What happens when an interment goes on?
The funeral procession
Okay.
will come into the cemetery. We would do the interment of the casket into the ground
Lowering it,
or
okay.
into the mausoleum. Obviously, our current community mausoleum is full.
Okay.
But at 3:30, it's over.
And the
So
construction in
anything
terms of digging the holes and all that happens?
before
Before
the
all
day
that.
before.
Okay.
Yeah, and everything is prepped for the day of.
But you're pointing out that the traffic.
At 3:30.
Is a morning traffic and it's really not
Yes.
afternoon traffic.
Yes.
Activity.
I just
The
want-
limited traffic there is.
Yeah.
I'll say I'm a homeschool person by background and that the traffic's bad in the morning too. But you're not getting around that. Okay, so you can clean up the afternoon traffic.
So I'm
Great.
saying, yeah.
I was gonna see if Mr. Ginsburg or Hervé would like to make a comment about any of this.
No.
Just like that. All right.
Does anyone on the board have any more comments,
Questions?
concerns, questions?
I mean, I would just say before you, if you're gonna close it, if the four of you are in favor of this, then go ahead and close it. But for me, I think there's something unique about the property. I think there's a hardship. I think it makes sense to grant this, assuming they go and get the use approval. But I just think this is not the minimum adjustment necessary, and sympathetic to making sure that financially it makes sense. But I think 12 feet above the height limit is too much. Not saying you can't go above it at all, and I like the pitched roof, and 2 parking spaces is too few. So, I mean, my recommendation would be, unless the four of you want to approve it, is that we continue this and you guys think about whether you can bring the height down a little bit, whether you can add some parking to at least allow for, if my math is right, probably 100 people per year coming to the office to do a meeting about the internment that's going to happen for their family, and having more than 2 spaces for that, and or some plan for wayfaring signs or something that can give the neighbors a little bit more comfort about what's going to happen when there's 2,100 more spaces there. So that's just my
I
thoughts.
like that comment.
I'm thinking more along the lines that Kevin is.
I kind of was too. I'm sorry. It's big.
It doesn't seem, based on what's currently there, this is completely different. And I'm sympathetic to the economic argument, but I think it's, I'd have a hard time understanding why 42 feet would be appropriate. I don't see that.
I mean, are you saying that you'd rather the pitched roof go away? Because
Yeah,
that's
the mechanicals argument doesn't hold a lot of weight for me personally. I'm not sure how other board members feel about that, but that to me is, you'd like to maximize the space for putting the bodies. and you would like to take some extra height to use that space for the mechanicals. So I unfortunately, that to me also sounds like an economic argument.
Well, I guess yes and no. I mean, from my standpoint on the pitched roof is, in my opinion, and as presented, it looks aesthetically more pleasing. And
I don't disagree with that, but
especially-
you could still do that. You would just lose this space for the other use, right? On if you did the pitch, but you did it at a lower height.
Any loss of space obviously limits the number of crypts and niches and
And we're
produces
sympathetic to
less
that.
less of a useful life for the cemetery proper as a whole. That's one of the issues we're definitely working with here. The flat roof is really minimally above the 30 feet, and only because of the average grade calculation and the hardships that we're dealing with at the site specific.
So currently, when you look at it from the road, because of the slope, there's not much of the building that, to my view, is above the road that you can see. I think that's part of what I'm trying to understand is how much higher will the 42 feet, what height could you bring it to that would be reasonable, given that the current height is significantly lower than what you would see from the road?
I think under that description, we can kind of draw a picture there.
Yeah.
And I don't have an exact height of the current structure. I could certainly get one. But you're talking about a story and a pitched roof.
Mm-hmm.
Here, you're talking about.
You need the microphone.
Oh, sorry.
Sorry, thank you.
Thank you for the reminder.
Thank you.
Here you're talking about, where is it? A flat roof off the front of Camp Ave.
Right.
That's 26 feet.
Okay, so what you're saying is the existing is 26 feet?
No, this is higher than 26 feet, but it's not an inordinate amount. Whereas the existing will be similar in height to the flat. I'm not saying the pitched roof, but recall that the pitched roof, based upon this perspective.
Well, the existing is not anywhere near 26.
No, you're talking about a full
Yeah.
story and then the pitched roof.
Yeah.
15 feet,
It's probably.
between 15 and 20 feet. I would say that's an accurate statement, and I can get an exact on it.
I think what also would, and you can decide what to do, but I think somebody mentioned, like, what's the existing square footage of what's there right now? Right?
That was my
'Cause-
first question.
Yeah.
I mean, I could,
Like
if you give me a
that's
minute,
gonna
I
be-
could
that's
pull the
gonna be
tax.
important at some
I
point.
did not bring the tax card with me,
One at a time. Speak one at a time, please.
but if, I can certainly look up online and get you the existing square footage. We can certainly get you the existing height. I will represent that I don't think the height of the flat roof, and I have to be careful with what I say, the height of the flat roof off of Camp Avenue is going to be a significant change from what's there now, considering the slope of the site and the fact that it's a flat roof.
I think that would be very useful if you could help us understand what the existing height is off of the road versus what the proposed would be.
Well, and the other factor is the existing building is maybe 25 feet wide. The proposed is 80. And the depth is a whole nother story. So it's definitely a much bigger building at that spot.
No one's denying that it's a
Yeah.
bigger building,
Right.
but we're also on 36 acres of property, and it's a cemetery. These type of uses are reasonable and common in a cemetery, and this is an alternate to this cemetery closing, essentially.
What happens when the cemetery closes?
That
Does
just
anybody
means
know?
there's
I know.
no more.
I don't wanna
no
even
more-
go there.
No more plots available?
Woody, did you want to make a suggestion?
Yeah, I just wanted to comment that the proposed parking has some dimensional limitations that are of concern to staff. Back up from, some of them would be right at the Camp Avenue road edge because it's compressed. So it may be worth continuing the hearing to try to get some of your questions clarified, and maybe see if they could do something about improving the parking, maybe widening it, as I think it's been suggested, adding more spaces.
Yeah, I mean, just speaking for myself, and I'm not gonna tell you how to design your building, I'm not an expert in design, I like the pitch roof, but for me, if we close it today, I'm gonna vote no because I think the parking is not sufficient. Albeit I take your point that it's very passive and people on Interment Day will park in the greater cemetery area. The parking's not sufficient, the building's too tall and too bulky. So that's just my view as of now, and I think it'd be wise to try to figure out a way to come up with some solutions to that and come back to us, but you decide what you want to do.
If I could take, if you don't mind, if I could take the temperature of other board members?
No, we don't do that. It's up to the chair if you want to continue the hearing or not.
It's a risk on your part to, do you guys want to make any comments to him?
I think I've already kind of
Already have.
indicated which way
Yeah.
I'm leaning.
And maybe, if we were to continue this, maybe you could come back with a little more detail about some of the existing nonconformities that would be reduced.
It's one. It's one. It's the front yard setback on the existing. Currently, and I can look at the ZLS.
Well, there's the FEMA thing with the height of the 72 feet, 72 elevation.
Correct. I mean, we are
76.
raising it to comply with the base flood elevation plus one. I don't know if that's a concern with the existing or not.
Well, the other thing that was mentioned was that you would be moving more of the mechanical things into a garage, or you
Correct.
wouldn't have as much equipment.
Correct. The
out.
maintenance area would definitely be improved than what it currently is.
Mr. Smith?
I would just like to add that the existing building is also in the same flood zone, up to AE 76. So the new building going up to slab elevation 77 would remove a pre-existing non-conforming from a flood prone area.
Okay.
It sounds like, we'd like to keep the hearing open. If I may, Madam Chair, ask a question to kind of get some commentary on potential comeback.
Yes.
The parking area, when you're talking about more parking, you want to see more parking off of Camp Avenue? Or, do you want to limit that to?
I think there's a couple of concerns. One is the width of the spots and whatever Woody addressed in terms of turning radius or whatever that is. And number two is some recognition that there is going to be additional people coming there. I know it's passive, but Woody in particular was concerned about people coming and visiting the office. And I don't know if you addressed that sufficiently with wayfinding signs, or you can figure out a way to get 5 spots instead of 2 so that there can be signs saying, okay, if you are coming to the office, you have somewhere to park. For me, I'm not sure what the right answer is. I just feel like 2 spots and 20,000 square feet is too much.
I'll be honest, I don't know if we're going to be able to get more spots up off Camp Avenue.
But again, I'm going to look at it holistically, and that's just one of the concerns, and just taken together for me right now, it's not there to grant the variance.
They may be said another way, if you have room for 21,000 square feet, you have room for more parking. It would be at a sacrifice for some of the building space, but by definition, if you're saying you could build a 21,000 square foot building, there is room for parking, I think is maybe another way of saying it.
So your concern is parking off Camp Avenue, is that the concern, is that there's not
Correct.
sufficient? So wayfaring signs are prohibiting parking off Camp Ave and pointing everything into the cemetery proper would not be a viable option?
Well, I guess what I think is there's 2 or 3 spots or whatever there, and somebody puts their blinker on, pulls in off of Camp Ave, realizes they can't park anywhere, can't turn around anywhere, then is backing onto Camp Ave. There's train tracks right there. I think, I don't even love the parking up there at all, but obviously there's existing parking there, so it's gonna be, it's a challenge.
If you were to continue, you could work with staff to make sure that the parking is fleshed out so that that issue is eliminated. And I would look at it from a safety standpoint, turnaround and mobility through the lot. I am concerned as this stands now that you wouldn't get the votes you need to pass it. I don't mind a big building there. It's a big property, but I think this is pretty big scale relative to what was there. So I just want to understand that more and see maybe the compromises with parking, the safety issues, and the neighbors, what they addressed tonight. If you can show us that you've committed to some kind of landscaping plan. I know that gets kicked up to planning and zoning. So it's your call if you want to close it or continue it.
No, I think I'd be foolish to close. So I request the hearing be held open.
Okay? So we will continue this hearing. We'll have you work with staff on the parking issues and anything else that came up tonight. And you can come back and present at our next meeting. We're thinking February?
February 15th.
February 15th?
My birthday.
Oh, happy birthday, Bonnie.
February.
Okay. Anybody else wish to be heard on this hearing?
Just one question.
Yes. Please come up.
I'm A in a rush, my wife Ann, 241 Hoyt Street. If the property is elevated to take care of the flooding, where does that excess water go? Is there plans to redirect that somewhere?
I assume there would be an engineering study as part of the bill. That's typically what happens for planning and zoning, correct?
Hopefully it doesn't come into
Correct.
our yard.
Yeah.
Did you get his name? Did you get his name?
No, I didn't.
There would be a drainage plan. We would stipulate that. That's usually standard. But thank you. It's a good
Yeah, I guess when you
concern.
guys come back, if you could address.
What was your name again, sir?
Rush.
Yes.
Rush?
R-U-S-H-E.
Your first, I'm sorry?
Aina, E-A-N-N-A.
Okay.
Thanks.
Thank you.
I don't know if you want to better address that, but I will state for the record, yes, there will be drainage, soil and sedimentation and control measures. There's all that will go into the planning and zoning review process to handle flooding.
Thank you. There's nothing else. I'm going to close this hearing. We're going to take a quick pit stop. I'm sorry. We're going to continue this hearing. Oh my God, there's on the record. We're going to continue this hearing. Thank you very much.
Thank you.
Thank you, Brian. You will do a quick pit stop and then we'll deliberate and get into it real quickly. Bonnie?
Yep.
Yes? Okay. All right. 2 minutes, go.
You just need to stand up.
After a brief pit stop.
We are now back on the record.
Oh, thank you. Bonnie says that.
Yes.
Thank you, Bonnie.
You're welcome.
All right.
That's why they pay me the big bucks.
So let's start with calendar number 10/20/20. 22. This is the Cindy Hardy Peach Hill case. I'm going to defer to Kevin on this. I don't think we have enough information. I would defer to town council to help guide us through this.
I mean, my view is that it's really straightforward. I am sympathetic to the Cindy's Hardy?
Yeah.
To their view, which is, it really is kind of unfair that you can print something in a newspaper and then that sits there for 30 days and, you know, but the reality is that's what the state statute says. And we're bound by following the state statute. Despite what her counsel said, we are not the appropriate body to determine that that statute is unconstitutional. We have no authority whatsoever to make that determination. Ours is to follow the law, which says we can hear an appeal if it is properly filed within 30 days of notice being provided, and one of the places it can be provided is in a newspaper with substantial circulation. And based on my own knowledge of the town and the Stamford Advocate and its circulation in our town, and based on the comments from the town council and others about us, the town, using it as a means to advertise, I think it's clear cut that as unfortunate as it may be and as unfair as it may be, the statute was not complied with and this appeal is not timely. And the only other comment I would make is, where in their notice that was published in the Stamford Advocate, they reference appeal being made to the Building Board of Appeals,
Yes.
as opposed to the Zoning Board of Appeals. I don't think that is sufficient to disrupt the notice that they were given. I think they were given constructive notice, and the fact that it referenced the Building Board of Appeals instead of the Zoning Board of Appeals
I think it was
is
both.
not a
Yeah,
fatal. I
It
think,
referenced both.
the statutes and decision of the to the building. Yeah, you're right. It does reference the Zoning Board of Appeals, but then it says you appeal to the Building Board of Appeals. But either way, I don't think that's a fatal error. I think they still would have had constructive notice based on the statute, and so.
You do feel like this was adequate constructive notice?
Yes.
It met the definition in your mind?
Yes, and what the state statute
Okay.
said is that the clock begins at the earlier of, and then it lists three things, and one of them is the publication in the newspaper. So they had to file their notice by July 10th, 2022. They did not, so I don't think we have any choice other than to reject the appeal based on them not having timely filed it.
Timely filed. Now, they are gonna appeal this, but based
That's
on what
right.
he said,
Right.
so, okay.
And if we voted the other way, the other side would appeal, and I think in that case we would lose. I believe in this case we'll win because the state statute is
Statute.
pretty clear. They may challenge the constitutionality of the statute itself. That's a different question, which I don't think they would be successful in any way, but that's.
Well, and the other thing is jurisdiction. I think if I heard town council correctly, it really should have been filed with the Building Board of Appeals, because it was for the building permit. So they incorrectly, in their request, if they had made it a zoning permit issue, we would have had jurisdiction, but they specifically referenced the building permit.
Right, so my view on that is, I'm not sure.
Okay.
I do not agree with their view that we have no authority whatsoever over the building official. I think if the building official makes a zoning determination, we should have the ability to review that. But having said that, I don't think we even need to get to that question.
The timing issue bumps.
Because I
Timing
think the
takes care of
timing
it. Yeah.
comes first, and they didn't hit the timing, so therefore all the rest is moot.
Okay.
That's my view. And so I'm prepared to vote now to reject, but I
Okay.
don't know how the rest of you feel.
Matt?
I completely agree with everything you said. Construction notice too, I mean, if we want to count it, they said they started construction soon after July 11th, so theoretically, there's some construction going on there that they would have noticed, and so that's yet another.
That would be an actual
If you
notice.
throw out the
Yeah.
Stamford Advocate, which I also agree that that's kind of it's a little bit ridiculous to assume that everybody's combing through the Stamford Advocate on a daily basis for these.
Yeah, I'm
kind of
sympathetic to that too.
Now, and I also point out too, that this isn't like, it's not like they had this isn't some neighbor that was blindsided by that construction project going up. They've gotten attorneys involved for over a year for this construction project. So at that point, I mean, they should be on the lookout for, the neighbor told me a year ago, we're gonna be doing construction, and they've been going back and forth with settlements. So they should be on the lookout for construction. So, I would vote to reject the appeal.
Okay.
I'm in the same camp as both.
Yeah.
You guys?
Town council thinks the Stanford Advocate is the proper notice.
Yeah.
I'm there.
So I just want to say on the record myself that even though I wasn't present for the first hearing, I reviewed the recording of it and I reviewed all the documents that have been submitted. And having said that, I make a motion to deny the appeal.
Does anyone second that motion?
I'll second it.
Matt, all in favor of the denial of the, how do I say it?
Appeal.
The denial of the appeal, all in favor? That is 5-0. The appeal is denied. Moving on, calendar number 14-2022. This is 35 Herman Avenue, Mr. Elvis Robles. Matt, you want to start this one?
Sure. I'm sympathetic to something that Kevin brought up when he was discussing, which is that this is not a legal non-conforming use of the property. And so it's not that we are allowing a legal non-use. This is not a legal.
It's an illegal.
Illegal non-conforming use of the property. So I am very sympathetic to somebody buying a property that they thought was a two-family unit, finding out it's a one-family unit. But if it has been illegally non-conforming, even since 1952, it's still illegally non-conforming and does not fit the character of the neighborhood in all likelihood as well, in terms of the lot size and the surrounding lots as well, to be a multifamily unit. So I would be in favor of rejecting this one as well, but I'd like to hear what other people have to say.
I agree with what Matt said. I don't think that the evidence supports that it should be designated as a two-family. I think what's there is not enough. And then in looking at, driving around and looking at the street, it is the only two-family. It does not fit with the character of the street at all. And I think it's a good opportunity for us to be able to put the street back to right and have it be a single-family home. So I am in favor of rejecting it as well.
John?
Yeah, I feel the same way as everybody else about Mr. Robles, but at some point in 2004, CO was issued as single family. What happened after that? That was either not disclosed to him before he bought it or whatnot. It's got to be a one. It's one family.
I like what Jana said, it's an opportunity to take it back to what it should have been. It may have slipped through. Kevin?
Yeah, I mean, I don't know if this is legally non-conforming or if it's an illegal non-conforming use. There's evidence that it's been used as a two-family home for many, many decades. But there's the 2004 certificate of occupancy that described it as a single-family home. And so it's unclear, and in such situations, my view that the burden is on the applicant to prove to us that in fact it is legally non-conforming. He couldn't convince the town's zoning officer, who I think is due some deference here, and didn't provide any additional information from our last meeting to prove that in fact it has been legally non-conforming and continually used as a two-family home since its inception, basically, since zoning would have prohibited it. So absent that compelling evidence, I agree with the rest of you.
And I'm a broker and I always say to our agents, you have to dig, you have to get all the information. I think he got the answer he wanted and they rested on that. I am completely sympathetic. He was bait and switched, but it was on him to dig further and establish if this was a two-family or not. So I think we're all on the same page. Does anybody want to make a motion to deny?
I'll make the motion.
Jana makes a motion to deny. Second?
Sure, I'll second.
Kevin, thank you. All in favor of denying the request? 5-0. Nice work, everybody. Sorry, Mr. Robles, I know. Okay. Then the last thing we're gonna do, moving to other, am I on track, right? We're moving to other business? Okay, and other business stays on the record, correct?
Bonnie can depart now, sure.
Okay, great. Thank you, Bonnie.
Got a lot of outstanding things that we met on the way back, and I guess we can.
Yeah, we could do that. But the Giovanni's at the Water's Edge, Woody, you want to quickly summarize what's going on there?
Well, the bottom line is, we hold a bond, that ensured certain site improvements were done accurately. There were some changes made. I guess the question is whether we should accept the fact that it's not exactly according to the plans, which were so carefully put together, and what to do about it.
Well, let's say it different. They came to us for a variance. We granted it, but with certain stipulations and conditions about how wide certain things should be and plantings and other stuff. They've now and we insisted that they file a bond to make sure they comply with those obligations. They did not. And now they're asking for the bond to be released, right? Is that fair?
The state came in, right?
Well, the state did some work on the other side of,
Which made
on part of their property,
which made our suggestions somewhat obsolete.
but not entirely obsolete.
Not entirely. So, you know, and I think they've basically thrown out our recommendations now and just said, well, you know what, the state said it didn't matter anymore. I think it still does matter. We're trying to keep a certain quality and feeling to the neighborhood, so.
And let me say this, so I'm not saying that there is no scenario in which they should have their bond withheld or the bond remain in place unless they are strict in total compliance with our plans. But I need some explanation from them as to why and what the difference is before I would agree to release it.
I don't think I fully understand who has the authority, because I couldn't tell from what I read. Is the state truly in control of that, of the property that we're then asking them to make additional changes to?
It is the state's property now.
Okay.
Typically, you get a permit from the state to modify the road edge and the right-of-way land for driveways and other things.
Okay.
In this case, it appears that the Giovanni's management did not seek a state permit and did not provide the ZBA-approved and carefully stipulated plans to the state and say, hey, part of your bridge project, I'm obligated to do this work. Well, you do this work instead. We need to get a permit and get it done accurately according to this plan.
Okay.
Seems like something broke down and there wasn't any effort to come here and ask for amended plans. So
you feel like they're punting and saying it's really not our fault, but you're saying they had an obligation and they didn't actually follow through.
It doesn't appear that they fully tried to do the ZBA-approved site improvements. But we do have an issue. That is that the state, apparently maintenance department, asked that there be some more open area for their trucks to enter from Stamford and turn around in front of Giovanni's and head back in the other direction, and that they wouldn't want the island to be so big and the opening to be so wide. So I'm not sure if we could even call their bond and do the work with a state permit ourselves. So we may be pretty much stuck with the curbs and the way they are. But I think one of the questions is, could there be some additional compensation done? And I think one of our members, Gary, suggested, is there some horse trading with plants, with some more trees? Is there something that could be done to improve the buffer separating this expanded canopy building from the road edge? And I think that's something we could look at.
And Gary was on a subcommittee that was formed that oversaw the variance that was granted many years ago. But either way, my view is we need something more. We need a presentation from them. We need them to negotiate with Gary or do something to give us more information and or some sort of consideration in exchange for not complying with our.
I agree. We're not just going to turn over the money without some kind of discussion.
So
Is that the point?
we can just table the matter to the
Okay.
next meeting.
Table the matter until we get more information? Is that what we're
Well,
doing?
the answer's gonna be, yeah, right, no, unless they provide something.
Okay.
And by the way, also, I'd like something from the state other than, Woody, did you talk to the state, or did they say?
No,
this is what the
actually,
state
with
said?
Jeremy's help, there was some effort to try to find somebody in the state who could answer. Can we change the island? Can we make it the way it was supposed to be? Why wasn't it done the way it was supposed to be? And we eventually got an answer.
Can we ask Jeremy? Can I ask him about it?
Okay.
Jeremy, can you want to comment?
The state told you they may want that turnaround? Or does that come from Giovanni's?
Jeremy Ginsburg, Planning and Zoning Director. We did reach out to the state of Connecticut to, exactly what Woody said. Figure out, is the state done out there? They've been out there for years, working on the Northern Bridge project. So we had to circle back to the state and say, number one, are you guys done working? Is this the end product? And the answer was yes. First, we had to find the person at DOT because there's been a lot of turnover, people that work at that project. So I did track down a person who can answer those questions. As a state, we're done. And as a state, we are not likely to approve significant changes to what is out there right now. Could they, in response to your question, would they approve some more plantings or a different plant? But as Woody acknowledged correctly, is that what they wanted was a wider turnaround than what ZBA approved.
And so they
The
had told you that, we have that information directly from DOT to you, saying we want the wider turnaround for plowing vehicles?
I think that was it an
Close.
email
It's a little
or
shaky
a call?
how they phrased it. But
I think what I got
we can
in-
certainly provide it.
I get your point. Is this official or is this word of mouth?
What I got in an email from them is changes are not likely to be approved by DOT because again, this whole island is on DOT's property.
Okay.
So is this even worth tabling? Are we going to get anywhere with this? It's worth trying.
I don't
Well,
know
it
if I
makes-
understand
in terms of the
this,
planting,
but what it says in the email back to Mr. Ginsburg is, and it's from the Transportation Engineer 3 from the CT Gov. It says the changes made were requested by DOT maintenance. Any changes to the width of the island would void our response to the initial request. It is not recommended that the changes be made. I think that's what you're.
That's what Woody said, is they wanted it wider.
Right.
And changes are not likely to be approved by DOT.
So that's
Again,
already right.
what does the word change mean? Does it mean narrower, different, or, would a tree be approved? I don't know.
What does a tree get us?
Pardon me?
Is that part of the original plan? There was supposed to be a bunch of
There
plantings
was
there
a
that
very
just never got
carefully
put in?
landscape architect planned.
Lighting,
planting.
everything.
It was mostly shrubs, though, in the front, where
Yeah.
we would like to get some, say, separation of this big building from our residential neighborhood.
So we had a,
So we could ask them to look into, could they add some trees, to add some thickness to the buffer, and see what they come back with.
And my view is they have unclean hands with this and with us, and I want Gary to negotiate something with them, and I don't want it to be the precedent that you can not comply with our stipulations and, have no consequence.
I agree.
Yeah.
Okay. Okay.
Okay. Jeremy, you good with that?
It's your decision, so we'll have Mr. Haslam, you have a memo from Mr. Haslam, we'll tell him that the ZBA wants a presentation next month.
Okay. You didn't spell your last name. We didn't have that. I was kidding. I was kidding.
You want Mr. Haslam to appear and to present.
That would be great. It's at our next hearing in February.
Yep.
Okay? Should we
Motion
bump
to
everything
adjourn?
else?
Sure.
Okay, I know, we've always got so much to do. I'm
Well,
sorry.
do we need to just grant the extensions?
Yeah, let's do that real quick. Kevin, give me one second.
do that.
Okay. Request, one-year extension. Thank you.
Thank
Hervé.
you.
Take care. William Hausberg and Abigail Hausberg at 6 Proud Island would have bumped another year extension. Woody, any reason not to do that?
No, I don't think so.
Okay?
I don't think
All in
it's-
favor of that? Aye, we'll include that, okay? Next one, request a 3-month extension on the Collier 65 pear tree. I'm okay with that. I heard the initial hearing. All in favor? Good. Request a 1-year extension on 25 Tokenique Trail. Woody, any reason for that?
No.
To deny that? These are all just permanent issues. They're waiting for stuff. I'm okay with that. Everybody? Okay? We're good?
Somebody made a motion, somebody seconded.
Yep, let's
Okay.
say Barb made a motion, Jana seconded, yeah.
That's fine.
All right, I'll just mention March 11, we have a webinar that we're all supposed to go to.
Okay, yeah, put that on your calendar. It's an all-day thing.
You don't have to actually be there.
What's the
Watch it.
options for people who are not here for that date? I'm
you can
not
watch it
here
from
on-
afar.
I'm also.
From the,
Wherever
from
it
the
may be.
beach and the Keys, no, thank you.
No, not there.
There's gotta be another option,
You won't
right?
be excommunicated.
Well, we'll find another option.
And by the way,
Save this
If you
packet.
find one, I
We'll
might
be
join
going
you,
back
because
to
that's
the
our kids'
mausoleum.
spring break.
yeah, and by the
Hang
way,
on to your
I
mausoleum
will
stuff.
guarantee you that the mausoleum people will come back next month, and lo and behold, we can.
Yeah.
That was just.
Wait.
that was-